See you later on. It's always a pleasure, sir. It's 9:23 a.m. Let me start off with this.
Yeah.
He's at which facility? Let's get into the situation. Counsel, I give you back your documents.
Your documents, but not yours, sir.
I signed it and I gave it to the lady just went out.
Oh, okay.
Hey, do me a favor, Joe.
Yeah, man.
The lady that just went out the truck, I signed and gave it to her. Yeah, I signed his documents and gave it to the lady that just went out. She still there? Counselor, she's got it, sir. Thank you.
Much.
Is my name tag in the front of this thing? Okay, thank you, ma'am. Deputy, somebody forgot to get my name tag in front of this thing. I don't know if people thinking I'm Jay Hurley. That Jay Hurley name up there? All right. Yeah, I want to meet, you know what I mean? You stop looking at me, man. Teresa Francisca Puglisi, which area?
North Broward, Your Honor.
All right, we at North Broward. Teresa, how are you doing?
Okay.
All right, I'm setting your bond. I do find PC for domestic battery violence. I'm gonna set it for $3,500. At this point in time, you $3,500. You allegedly took a bite out of a man. At this point in time, I'm gonna order you not to have any contact with Victor Bruzioni. Do you understand?
Yes.
Thank you.
Your Honor, can defense counsel be heard?
Go ahead, madam.
Your Honor, I'm asking to see if
Ma'am, I don't
Mrs.
mean to be sarcastic. No one knows you but your mother, your father, your grandmother. Give us your name, counselor.
Candia Batchelor, Assistant Public Defender.
I know you quite well, but the know you.
Got
Keep
it.
this bachelor. Go ahead, ma'am. You may be heard.
Thank you, Your Honor. For Mrs. Puglisi, before she departs, if we can briefly recall her, I'm just trying to find out if she has any criminal history.
Teresa, come on back.
Understanding that it is a domestic violence case, Your Honor, and based off the PC, some of the allegations were
Bachelor,
maybe.
let her know what's going on. Ms. Batchelor, I had set your bond at $3,500, but your lawyer wishes to make some arguments and to discuss other matters. Do you have a second? Do you have a second,
Yes.
Ms. Puglisi?
Yes.
Okay, go ahead, Ms. Batchelor.
So, in Ms. Puglisi's case, Your Honor, I'm just asking if the bond can be lowered in any way. I don't know if she has any criminal history. Understanding this is a domestic violence case, alcohol may have been a factor in this case. If Your Honor wants to order, maybe reduce the bond and say that she cannot have any alcohol or intoxicants in her system as an additive to have the bond reduced. In addition, Your Honor, there is a no contact order potentially in place with the victim. However, they resided together, so all her belongings are at this place. If she is able to bond out, if Your Honor is inclined to reduce her bond and not allow her to have any intoxicants in her body, if you can allow there to have some arrangement to get her belongings so that she can be living or residing somewhere else with her stuff.
Bachelor, when that old man of yours pulled your vodka down the sink, he said you went crazy.
He what?
When your old man said he poured the vodka down, you was drinking this vodka and you were drunk, he tried to pour it down the sink. He said you went crazy when you saw that vodka going down the sink. Where you work at?
I haven't been working.
All righty. What's y'all relationship, you and that guy? Y'all living together?
We've been for 2 years.
All right. Mr. Pryor.
Yes, Your Honor.
I'm inclined just to go ahead. Has he came by to see you since you've been locked up? Has he called you or anything like that?
You can't here.
They don't give you a phone call like they used to in the old days?
You can't call out from here.
I thought they used to give you a phone call.
Yeah.
Do me a favor, pre-trial.
Your Honor, I wouldn't object to pretrial, but it's going to have to be a condition where it's obviously no contact. That stays in place. Just to give you a little background, she does have a prior battery in 2013. And also she has another battery arrest, but that was resolved. I believe it was either no prost here in Broward County, and it was a domestic violence issue that was in front of Judge
Is that
McHugh.
another domestic violence?
Yes, Your Honor, but it was an arrest in August of 2015.
It'll stay. That's 2015 is last year.
Last year, yes, Your Honor.
3,500 will stand. Thank you. Arguments are noted. Thank you, ma'am. At this point in time, where's Clavin Lee Pope?
2,000?
Come on, Clavin.
There, no problem. Judge, I have
North Broward.
North Broward.
his brother and his sister-in-law here.
All right, Clayton, come on up here, folks. Allegedly, I need to have the question answered. How old is the child that he was whipping or whatever?
27.
27-year-old? There ain't no child, is it?
No.
All right, y'all raise your hand. Who are y'all two? Do y'all swear to tell the truth, the whole truth, that nothing but truth of God?
Yes.
Your
All
Honor.
right, Father, who are you, sir?
I'm brother, Robert Pope.
You his brother?
Yes, sir.
And who are you, ma'am?
Sister-in-law.
All right, so y'all two married.
Yes, sir.
Which one of y'all speaks for the family?
Well, the both of us.
I ain't know both of us.
He
Who's the
do.
head of the house?
I am, Your Honor.
You know your wife in charge.
You got it.
That's why I said both of us.
He in charge of the house. All right. Where does Clayton work at?
He's not currently working right now. He was working for the school board, and
He works for the school board?
He was, but
he was working for the school board.
What do you do for the school board?
He's the head custodial.
Which school?
He's at Knob Hill Elementary. But he had the sick leave for over a year now. So he's not able to go back to work.
Okay, you swear both of y'all, what y'all just told us, court is the truth, the whole truth, and God?
Yes.
All righty. At this point in time, I do find PC for the so-called battery against his own alleged daughter, who's 27, criminal mischief and misdemeanor battery. I was going to be inclined to set bond at $3,500, but let me hear from you. Do you wish to add anything, State?
Your Honor, no. He has no priors when I did a check on CCIS. Obviously, I haven't done a full national criminal check. In light of that, Your Honor, I wouldn't object to him being placed on pretrial, level one or what. I'll defer to the court, but at the very least, level 2 pretrial, Your Honor.
Okay, I was the one that set up that pretrial program when I was the sheriff's lawyer. Who done added some level 1, level 2? What in God's name is level 1, level 2? Y'all got all sophisticated on me. I just put down together a program.
Okay.
That federal judge wanted me to come up with something. What's a level 1, man? What does that mean?
Your Honor, level 1 is just a strict house arrest, Your Honor.
All right.
And level 2 is just pretty much he can go to church, work, grocery shopping, and purposes for work, Your Honor.
All right.
May defense counsel be heard, Your Honor?
Yeah, go ahead, let me hear from you.
Understanding that his family's here to support him as well and has been waiting to find out if there will be a bond set. He does have medical issues. He's lived in Broward County for 49 years, so he's not a flight risk, Your Honor. He does not live with the alleged victim, so he resides somewhere else. If Your Honor is inclined to place him on pretrial, I would be asking for an open schedule just for him to call in and make sure he checks in with pretrial.
Is that a level 1?
That's a standard.
Standard, Your Honor. I'll defer to the court, Your Honor.
Y'all know last Thanksgiving, November 26th? Was y'all around last Thanksgiving?
Yes, sir.
Was he at y'all table? He being Cleveland?
Yes, sir.
Was his daughter there?
No.
Why wasn't his daughter there?
It's a strange relationship between the two, so it's not like, close. It's just, they just got a relationship there. It's a little tense there.
What did you make that day? You made the turkey?
Turkey, stuffing,
Which one? Did you make that turkey?
yes.
Was it dry?
No. I could cook.
I had a woman make you a dry turkey one time.
No. I might lose my husband. I cook a dry turkey.
I'm gonna go ahead. Clayton, I know this thing with your daughter. I'm gonna go ahead and just give you standard pretrial release. Pretrial, will you go ahead and take him? Yeah, make sure no harmful contact. In fact, no contact with your daughter until you get this sorted out, okay?
Okay.
No contact with the man.
Your Honor, and may I interject in relation to Florida Statute 903.047? We ask that he be prohibited from being within 500 feet of the victim wherever she resides, and that, as you stated earlier, that there be no contact with her, especially electronically or in any manner through a third party.
Okay, Clayton, you can't go within 1,000 feet of your daughter, you understand?
Yes.
Until we get this case resolved, okay? Don't go within 1,000 feet of her. I had your bond set at something like 3,500 or more. But your people done came in and spoke highly of you and spoke for you, okay? So
Okay.
take care of yourself. You get out today, all right? But don't go anywhere near 1,000 feet of your daughter until we get this thing sorted out, okay?
Okay.
And your daughter should be at your Thanksgiving table. You understand it, don't you? Well, I have a Thanksgiving table. Okay, thank you, sir.
Thank you.
It's a pleasure to meet
Thank
y'all.
you, Your
Thank
Honor.
y'all.
Thank
Pleasure
you.
to you.
Thank you.
Your Honor,
Yes,
Your Honor,
Carol,
sorry.
Read.
Your Honor, not to interrupt the court.
Yeah, go ahead.
The deputies have been calling from North Broward. They need it's John Johnson. It's our page 8. John Johnson.
Is it domestic violence or
You
just
want to deal with them now? No problem. Okay, let me go to my docket. I don't know I don't have page numbers like y'all do.
Yeah, I don't have page numbers either.
John Johnson. I don't know.
Pay this to him like
Okay, I got John Johnson. Let's go to John. John, how are you doing?
Okay.
I'm all right.
All righty. Your bond is set at $25. I found PC for trespass. I decided to go ahead and keep it at 25. Okay, sir? I need you. Yeah, I'm gonna keep it at 25. Okay?
Yeah.
Good luck, sir. Take care of yourself. Bond is set at 25.
I can't bond. I ain't got the money.
All right. Well, we'll have it brought before a judge sometime
No
later on.
contest. No contest.
No, it's $25. I need to get him.
No
He
contest.
needs, yeah, I'm not sure she's mentally even fit.
No contest.
He's clearly out of it. I'm gonna go ahead. Your bond is $25. It would be unprofessional and unethical for me to take his bond like this. He's out of it. Come on, I'm going, guys. I gotta move on. 25. Yeah, he's laughing and having a good time. I need to go ahead. You want to do what now with that?
Order a mental health,
Deputy,
mental health evaluation
I need a
while in
mental health
custody.
evaluation on that man. Do you understand, sir?
Yes.
I'm gonna order it and something will come through. Okay?
Okay.
Okay. Thank you. I need a mental health evaluation on him. Where's McNeil Reed?
Judge, Mr. Reed is present at the main jail.
All right. Reed, where are you?
Right here, sir.
Hey, man, I got you for a violation of injunction. I got your bond set at $5,000. All right?
Judge.
It is what it is, sir.
Judge, is there proof of service other than the allegation in the probable cause affidavit? Because when I checked on Odyssey this morning, this injunction was pulled on the 8th.
Counselor, and that's what...
And-
Yeah, that's what concerned me. Here's the problem. I've got the defendant acknowledging that he wasn't supposed to be at the residence, but he's saying he did not know there was an injunction against him. And that's possible because the address was off a little bit. State, let me hear from you.
Your Honor, this state's contention on that. I haven't been able to locate that on Odyssey, but based on the admission from the defendant and the fact that he did know that he wasn't supposed to be there, I think it infers that he knew that there was an injunction and he wasn't supposed to be there, and I think there's no probable cause to go forward, Your Honor.
Judge, I would counter that acknowledging that there is a reason not to be at a certain place is not the same as legal service, and that the state cannot go forward with a violation of an injunction that was not properly served. And I would ask that he be released on his own recognizance. He is aware that he's not to be at this place now, and there will be no further issues.
Mr. Miller, again, I have a different reading of the law than you do. I'm going to go ahead. I had bond initially set for $5,000. I'm going to go ahead and set it for $3,000. Bond is set at $3,000. All right, at this point in time, now you know. Thank you. Good luck. Mr. Miller, I didn't know you were here. How are you doing, sir?
I'm well, sir.
Good to see you again. It's a pleasure, sir. All right, Elvin Potis, where are you, Elvin? No contact with her. Stay away from her. Lots of fish in the sea. Find another one. Where's Elvis Potis?
POTUS?
Oh, Your Honor, was that
And he-
official? That's a good
He's
question. Your
declined
Honor,
my services
Yeah, I'm sorry.
this morning.
back to Mr. Reed. Has there
Let's go
been
back to Mr. Reed.
on the record? Has there been an official statement as to no contact with the victim? That
Yeah,
there be no
come back,
harmful,
Mr. Reed.
violent, or offensive contact electronically or through a third person, and he's not allowed to be within 500 feet of her, Your Honor. This is
All right.
pursuant to Florida statute.
Again, you can't be
903.047.
within 500 feet of her. You can't go anywhere near her. Do you understand?
Judge, Mr. Reed has a child with the alleged victim in this case. Would it be okay if a third party contacts that woman so that he can visit with his child?
Again, at this time, I'm going to say no. You can speak with the so-called judge, who's actually the assigned judge. At this point, I'm going to go ahead and decline because I find it very hard if I say I can see the child and then the mother says I don't want him near my child or me, it's going to create a headache. So let a judge review that. Who's the judge who's assigned? Thank you. I'm done with this. Where's Elvis Potis?
You reduced that to 3,000, Your Honor?
Yeah, 3,000.
I'm sorry? Yeah, it's been reduced. Where's Elvis Potis?
Thank you, ma'am.
Main jail.
Huh?
He's in main jail.
Elvin, can you hear me? Elvin. Allegedly, you struck and scratched a woman. Y'all had just left the movie and y'all was fighting over finances. What movie did y'all go see? What was the name of the movie so I can make sure I don't go see it?
Yeah.
Is that movie any good?
It's okay.
All right. Y'all leaving the movie, y'all got in a fight over finances. I was gonna take my wife to see Deadpool in about a week. I'm gonna tell her no. Now, I got your bond set at $5,000. What's your argument, defense estate?
If you can please.
Your Honor, based on a probable cause affidavit, we'll defer to the court on this.
It's probable cause for domestic violence battery, striking and scratching her. Go ahead.
We'll defer to the court, Your Honor.
Okay, I'm gonna go ahead. I had your bond set at $5,000. I'm gonna reduce it to $3,000. Allegedly, in the probable cause, the so-called female does not wish to prosecute. However, I do understand that this action is not between you and the female, it's between the state and you. So I will set it at $3,000. No contact with her, do you understand?
Yes.
So you get this thing resolved. Thank you. Where's Judge Lee Dixon?
Johnny?
Main jail.
Johnson, I got you for a violation of probation against injunctive order. It looks like the cop that just told you and served you the restraining order, allegedly you came right back there. I'm gonna set your bond at $10,000 because you're not taking it seriously, sir. Your bond is set at $10,000. Don't go near the woman, do you understand?
Your Honor.
Don't go near her. Go ahead, I'm sorry.
Your Honor, the state would recommend, once again, it's only a recommendation that the court revoke his bond. He currently has an open case in front of Judge Merrigan. I have the court case number. It's 1-4.
What's the charge?
Possession of cocaine with the intent to deliver or sell.
You want to revoke his bond based upon that?
Yes, Your Honor.
You legally can. Defense, what's your thoughts on it? It is what it is.
My position is that if the state is moving this court,
The state is
revoke the
recommending, to be clear for the record, the state is recommending. We're not making an official motion. We're recommending that the court revoke his bond. There's been no
Judge,
official
that is a
motion filed by
difference
the
without
state.
it. Judge, that is a difference without a distinction. The court is in fact moving, I mean, the state is in fact moving this court to revoke this man's bond. If that's the case, then we need to have follow the procedures. This man is entitled to due process. We're entitled to 3 hours notice, and we'll be happy to look at any motions that the state wants to file.
Bond will remain at $10,000. I want this set in front of Judge Merrigan. State, does Judge Merrigan have the opportunity to revoke his own bond?
Yes, Your Honor.
He does. Let Judge Merrigan hear this tomorrow morning. I'm done with it.
Yes, Your Honor.
Tomorrow morning, this is set in front of Judge Merrigan to review his status. Right now, my bond is $10,000. Stay away from the woman. Do you understand?
Yes, I do, Your Honor.
Don't go near her. Thank you.
Your Honor, for the record,
Yes, ma'am.
Your Honor, for the record, one, if the state can tell me the case number that they just pronounced, and two,
Yeah, Bachelor, lease that case number.
Yeah. No.
Great, Bachelor.
14007700 CF10A. Possession of cocaine with intent to deliver.
Your Honor, Commission 1 Tuesday, Judge Merrigan's docket would be available to hear this matter. On Mondays, he only has calendar call. If Your Honor wants to set it as emergency, you can. I'm just letting you know.
But I'm not so sure that I would want to set that as an emergency. So it's
Yeah,
just $10,000. They
yeah,
can
it's
set
just
it in front of
$10,000.
Merrigan. You can just talk to Merrigan.
What day are you setting it then, Your Honor?
Clerk, when are you going to set it?
Judge, you can get it on the docket faster than I can because no one is here today to set the hearing.
Right. And his next
So
court
if
date.
you call the JA, you can have it on the docket faster.
And his next court date in Merrigan is March 7th. So,
Perfect, March 7th.
yeah.
Yeah,
okay.
and again, the state can
Okay.
always, on its own, just
Yeah,
serve
well,
him and let
yeah.
him know, I want you to hear this,
Well,
Judge. I
fine.
mean, that's
It was
not-
just a recommendation.
No, it is what it is. Okay, Sedell Ted Visinor. I'm gonna go ahead and find, sir. I find PC for aggravated battery with the deadly weapon. Allegedly, you reversed the car and pinned the woman up against the construction barrier and you drug her backwards. The woman had to be taken to the hospital. I'm gonna go ahead. It's gonna be $10,000 bond. Mr. Miller, I'm hearing that there may be a Flocky issue, sir.
Keeps raising his hand.
We're talking about Wilson or Judge?
I'm hearing there may be a Flocka issue with the individual.
I didn't see that in the probable cause affidavit. Judge.
He alleges that he's going to be going to Broward College so he can eat the dean. Eating a person is generally something that's...
That's associated.
And he also kept rambling about trying to find a vehicle in the parking lot As I understood it, his sister is worried that she thinks he's on drugs, and he's been saying strange things throughout the past few days. As I went through this morning's docket, I saw so many indications of flocka just outright written in the document. I don't know. I'm going to put his bond at $10,000, but I need him to get a drug evaluation or some kind of mental health care. I don't want him out there because the guy is a danger to himself.
And
His own sister noticed it and was trying to get help. So I'm going to go ahead. My bond has been set. Who's this judge?
Your Honor, in light of that, and pursuant to Florida Statute 903.047, we ask that he be prohibited from communicating orally or any written form or electronically with his sister. He's prohibited from having physical or violent contact with her, and also that he be prohibited from being within 500 feet of his sister, just based on the facts of this case.
Because I would like him. His sister's trying to get him help.
Right.
If I cut the sister off from him, how do I get him to help? See, that new statute you're citing, because I never heard all of this.
Yes, Your Honor. It's regarding the conditions of pretrial release in relation to domestic.
When did this get passed, though?
October 1st, Your Honor.
Of last year?
Yes, and they required
that explains it because
right.
I've never heard of any of these conditions because the sister's trying to get her brother help.
Correct.
She's frustrated, and what we're saying is no contact with your sister. That's his only avenue of getting the help he needs.
Your Honor, I remember in the PC there is a mother, maybe the mother, the victim in the case is in fact the sister. Hopefully the mother can become more involved in that situation, but just in light of the facts of this case and the violent nature thereof, Your Honor, I'm just here to protect the sister.
No, we all have a duty to follow the law.
Right.
Miller, is that the new law that you know of? Do you know that? Is that the new law, Mr. Miller?
Judge, it's routine for the court in this situation to order no contact. I've never heard the statute cited, but I've never objected to the order.
Okay, I'm going to go ahead and order it. It is what it is. Okay. Carla Brown.
Judge, before we turn the page on Mr.
Yes, sir.
Wilson, I think if we can get a mental health screen on him.
I need to get a
that
mental
might
health
be
screen on him
prudent.
quickly.
Yeah.
Thank you.
No, Judge.
Carla Brown is at North Broward.
Carla, how you doing?
No, sir, Your Honor. She's a medical reset.
I'll give it a medical reset, but she's got bonds already set on traffic capuses, but it's a medical reset. Thank you. Appreciate it. Where's Sharonda Sally at?
North Broward.
Sharonda, how you doing?
Good morning, all right.
All right. Sharonda, I got you for possession of cannabis. I did find PC. I'm just going to set your bond at $100, but you got a $500 traffic capias. Do you know that?
I have a what?
A $500 capias. You got to pay $500.
Yeah.
You aware of that?
Yeah.
Okay, well, you got 500 traffic capias, and you got just $100 at me. Good luck, okay?
Your Honor, may defense counsel be heard?
You may be heard.
On-
By the way, Bachelor, prior, I'm moving forward. Y'all got to say something. Y'all better speak up.
Correct, Your
Because
Honor.
I'll forget sometimes. Go ahead, Ms. Bachelor.
Respectfully, I didn't want to interrupt you, Your Honor. On Mrs. Sally, Your Honor, defense counsel is objecting to probable cause. It speaks about the officer going up to the vehicle for a equipment violation, and then marijuana is found where? On her person, on the passenger. We don't have anything. There's nothing that says that an odor of marijuana was emanating from the car, which gave him probable cause to further search. As far as I'm concerned, an equipment violation, it doesn't rise to the level for an officer to, one, ask the passenger to step out of their vehicle, or two, there's nothing in here that says anything about officer safety, where the officer said that for a safety act, nothing. It just says equipment violation, stop, and then marijuana is found.
Your Honor, there's two issues here, Your Honor. First of all, Wren, which is a Supreme Court case, it's a traffic violation. Officer is lawfully there. Secondly, she had a warrant out for arrest. Pursuant to that, he had to take her in. He was retrieved the cannabis pursuant to a search incident to a lawful arrest that she was being served with a warrant that was placed upon her. So, Your Honor, I believe probable cause is there.
It's clearly there. Good argument, Mr. Bachelor. At this point in time, the decision will stand. It's $100 PC on the possession of cannabis. Mr. Pryor, you had the law right at your fingertips. Good. Thank you very much. Okay, thank you. Where's Joan Massaro?
Is that North Brown?
Joan, where are you?
North Broward.
All right, let's go to North Broward. Joan, they got you for battery on a firefighter, an officer, and trespassing. Yeah, I'm going to go ahead at my level. I'm going to go ahead and fine PC for trespass and set your bond at 50. And I do find that for battery on a law enforcement officer, it's going to be set for 1,000. The man said allegedly you tried to kick him in the groin, missed him, and got him in the abdomen. Let me be heard from you, Ms. Batchelor. What do you wish to add, madam?
Yes, Your Honor. Defense counsel's objection to PC is that this is apparently the location was at a food mart, which would be a supermarket of some sort. The PC doesn't say that this place was closed or that it was not open for business. At the end of the day, there's no call-in from any of the store employees saying that they want this individual trespassed. Looks like the officer walked up on this individual. She had been drinking what? Soda? What? Water? What? We don't know. And then he tells her that she needs to leave. It's a public place. There's nothing in the PC that said this location was closed, and therefore, my argument is that any individual, any citizen, any non-citizen is allowed to be in any public area as long as they're lawfully there. There's no PC for trespass.
Your Honor, Harold Brown, Bath State of Florida. If you look at the last page of the probable cause affidavit, it said that she was warned to leave the business several times. And she was also given the option to be taken home, and she denied both. So there's a statement there by the officer that she was warned to leave, she didn't leave, and then she was trespassed. Your Honor, I believe that there's probable cause. And also, if you look at the probable cause affidavit, it says it was at night, and she had been drinking, and there was a warning. When you look at the statute with trespass, property or structure or conveyance, it doesn't indicate that it has to be a closed venue or that it's at a certain time of the day, that you were actually given notice to leave, you didn't leave, and you're trespassed.
So, Your Honor, basically the state's presumption is that if I go to Publix and the officer tells me I'm shopping lawfully, I'm there lawfully, the officer says you need to leave because they just don't like the way I look, that I am now trespassed. There's nothing here that says that any of the store merchants or anybody said that she shouldn't be there. The officer walking up on somebody and saying you need to leave does not rise to the level of trespass. Why is the officer stopping them? Why was he called out there? Why is he now picking this lady out of everybody?
Okay, again, the case law is clear. The only issue for me is it likely more than not likely? That's all I care about. Now, you're going to have issues. The problem is the officer says while speaking to her, I observed that she's been drinking. I can say, well, maybe she was drinking water, maybe she was drinking Coke. But I think the rules require, I was reading a case last night, a judge has to bring his common sense and knowledge of the world. He's speaking of drinking alcohol. So again, I can pretend that at 11:18 p.m. at night, when the officer approached her, that she could have been drinking water or juice. I'm not going to play games, okay? It's drinking, it's alcohol. I'm going to go ahead, I do find PC. It's only likely more than not likely. That's my standard. Now, for motions later on, I've got grounds, but at this point, it's not my job to entertain motions. It's my job to say, is that PC for battery and trespass? At this point, there is. Now, you got some concerns here. It says she was warned to leave the business several times. Again, defense counsel, you're 100% correct. But at this point, it's not the issue for me to ferret the actual facts as to what the warning was, the nature of the warning, exactly what he was saying. It's only likely more than not.
He has to have the authority to trespass her, Your Honor. There's nothing in his PC that says he has the authority to trespass her.
Your Honor, right now,
there's no merchant, there's nobody who came out and said, we called, or that he is showing some insignia that he has authority on this premises to trespass anybody.
I disagree. I think you look at the PC, he didn't make contact with her because he was concerned about her trespassing. He says he approached her because she had been drinking. All right? He asked her if she had somewhere to go tonight. He was concerned about her safety. He wasn't going around trying to make an address. He asked her, she obviously had been drinking, do you have some place that you can go tonight? All right, somewhere you can go. And she wouldn't tell him his address. He was worried about her safety. He then asked her, can someone come pick you up? So you got an officer he's a drunk woman in front of an establishment at 11 something close to midnight. I expect him to ask this young lady, do you have someone that can come pick you up? Where's your address? Where do you intend to go? All righty? So to say that you acting as if this is a trespass case. This is not a trespass case. He approached her looking for her welfare and concerned about her as a young lady. Again, it's not that type of a case. Go ahead, Steve.
Your Honor, this is, once again, Your Honor, this is first appearance, Your Honor. We just determine whether or not there's probable cause. And all this is necessary for a motion to suppress or motion to dismiss.
So the concern I've got in defense counsel, this is going to be your argument. If the trespass ultimately fails at a motion, then you're going to be, the fact that she allegedly tried to kick him, that's the most gravamen of the offense. The $1,000 bond is if she tried to kick him, at the kicking stage, allegedly she was being put into his car. If the arrest is invalid, then that becomes another issue. Is the kicking actually going to be deemed to be valid or some type of a fruit?
Understand,
So you got some issues there, but I'm just saying at this stage right now, I don't deny you got issues, but at this stage, the issue for me is it likely more than not that she tried to kick an officer in the crouch and Mr. Scott hit him in the abdomen. That's the most salient thing I'm looking at right now. So I do find it for a probable cause. It's going to be a $1,000 bond. And this is such a, I don't mind putting her on pretrial. Does she have a record?
She's wanted out of New Jersey.
She's wanted?
Yeah.
Yes, out of New Jersey, warrant was issued 9/8/2015.
Is the warrant still open?
For New Jersey? Yes, Your Honor.
So there's a hold on her. She's gonna be
No, she
extradited.
doesn't have a hold, because
Oh.
it could be an incident wherein it could only in New Jersey wherein she may be aware of it, that's why she's in Florida.
It's a $1,000 bond. I'm going to remain. You got some issues, young lady. $1,000 bond on count one battery, $50. Thank you. All right.
Your Honor, for the record, she does work and she does go to school and she does have family in the community.
Okay.
And
I'll note
that's
that.
that's where family offense also, that she's wanted out, so it's probably a DV-related issue.
All right. Let's go. Courtney Doctor, what page? Where's Courtney at?
North Broward.
Courtney, is that you? Courtney, you got a no bond hold from Judge Solomon. I can't really touch that. Possession of our prisoner, I'm just going to go ahead and set bond at 1,000. I do find PC. You need to get back before Judge Solomon to get that no bond hold removed. Thank you. Good luck.
Your Honor, defense counsel's argument for PC in this case
Okay,
is
right.
that there was nothing asked of the arrestee, whether or not she was legally prescribed alprazolam or had legal possession. So as far as I'm concerned, possession of alprazolam may be lawful or it could be unlawful. There's nothing here that's saying that she didn't have a valid prescription.
Your Honor, that's not the standard, and that's not the job of law enforcement officer. She didn't dispel their suspicion that it was legally in her possession, Your Honor. Based on that, there's probable cause.
Yeah, that's my understanding.
Yeah, and it was confirmed to be a alprazolam, so it's confirmed.
Yeah, I used to carry like pills around, like a pill or two of penicillin in my pocket. I had an infection in my throat, and somebody told me one. I just carry one because I don't carry the whole bottle. They said, man, that pill is never self. One pill is, you be arrested for that for a felony. I said, I got the prescription at home. They said, that's not the point. So, an officer, so it is what it is. It's $1,000. I do find PC. I understand your argument, possession of this Xanax. Thank you. Where's Angela Dawson at?
She's at North Broward.
North Broward.
Okay, Angela, where are you?
I'm asking for mental health alert, also to fill out the detailed findings, Your Honor. mental health
Yeah,
alert.
she needs.
And she has family. Her sister is very concerned about her. Her sister takes care of her. She lives with her sister. And she does have a lot of medical issues. So
got
if Your Honor,
seizures too, seizures,
yes,
yeah.
if Your Honor is inclined to place her in some form of pre-trial so that her family can, her sister posted it?
She's posted it.
So her bonds be posted on all accounts? Angela, can you hear me?
We need a bond set.
Yes.
For which counts?
For 2 and 3, Your Honor, she has
Okay, the bond is set for 1,000 for grand theft. The sister posted it. I was inclined to go ahead and set the battery on law enforcement. Allegedly, she bit him, but it was bit him through his pants. It was like really
Right.
no effect. So I was gonna set bond for 500, but is the sister already posted 1,000?
Not yet, Your Honor, they're waiting for the bonds on 2 and 3. Once those are set, then the family will take care of the bond.
Would Your Honor be inclined to ROR on those and hold her on bond on grant theft?
Yeah, let me hear from you because that's my thought. Prior, she's already gonna post $1,000 bond. The family
Yeah.
trying to get the money together.
I agree. Based on the
Okay.
facts, Your Honor, I read the PC as well, Your Honor. I'll defer to the court.
Okay, it's gonna be RR, Madam Clerk, on counts 2 and 3. Counts 2 and 3 is RR. Good luck, young lady. Bachelor, should I go ahead and order that so-called Saki Valley?
You can put it on the findings record, if she bonds out, then her family will take care of her mental health.
Okay, put that on the findings order that if she bonds out, the family will take care of mental health issues.
Your Honor, could we hear another case of families here that's
Yeah.
present? Is that okay?
That guy with that suit on? What's your name?
Shane.
Come on up, I thought you was President Obama with that suit on. Where you was sitting there, I was gonna say something.
Was
Judge,
Crescento?
this is the mother of the.
Mom, Carter, how you doing?
Yes, cousin.
Cousin.
What is the child's name? Or the person's name? It could be a mother, but
Cal Percenti.
what's the name?
Cal Percenti.
Capleton. Capleton is on page number. Huh?
And I'll dock at page 12.
Okay, hold on, I'm looking for it. I don't know the page numbers. Spell the last name?
PERC.
TIE.
May I approach you, Your Honor?
You may.
Okay.
Okay. You know, Kirk, I'm getting so old. They say this is on percentage. Yeah, find it for me. Okay. You got it? I'll be fine. Okay, let's go to Cal Percenti. Let me talk to Mom, is that you? Raise your hand. Do you swear to tell the truth? Where's
Yes.
Cal at? The whole truth and nothing but the truth, self your God?
Yes, sir.
Mr. Miller. Mr. Miller, Miss Batchelor wanted to call someone out of turn. The mother is here.
Absolutely.
Can Cal
Who are we
Percentile
looking
come
for?
join us? Percenti? Cal Percenti. It says main jail. Cal, how are you doing? Raise your hand, sir. Do you swear to tell the truth? Cal, raise your hand.
Not
Do you
you.
swear to tell the truth, the whole truth, and nothing but the truth, self your God?
He doesn't really understand.
He doesn't hear the good?
He doesn't really understand.
It's partially disability.
Is he testifying, Judge?
It's partially,
Wow.
partially disability.
Wow.
They don't understand.
Raise your hand, sir. I got the mother. Yeah, you too.
Oh.
Do you swear to tell the truth, the whole truth, and nothing but the God?
Yes, sir.
Who are you to Cal?
I'm the cousin. This is my aunt.
Okay, let me read this
mother.
thing slowly. I got some other documents I need to read. Kyle's initially charged with battery on a firefighter, police officer, so forth. It was in reaction to a so-called L&L investigation. You said you are the wrong guy. For the record, have you seen this, Mr. Pryor?
Yes, Your no, I haven't.
Family Literacy ADT program?
No, Your Honor, I haven't.
Let me look at it first. Why can't I let you look at it before I look at it? Let him look at it first. In case he's any objections to me looking at it.
This is literacy program, life skills.
Yeah.
Yes.
The documents I should have handed to you earlier, Harold, sorry. That was just the information that family gave to you in the morning about his intellectual disability.
Okay.
All righty. For the record, I'm reviewing the Raphael Family Literacy ADT program. Mr. Pryor,
Yes, Your Honor.
I hate talking after him because I have to lay a record for the
Correct.
appeals courts.
Correct.
And I do it a lot in juvenile, but juvenile is a little bit different. On the Lou Lascivious, cops are looking for a man. Does the state have any inclination that he was involved in it? I'm gonna go ahead and make my finding. I found him
Yeah.
for battery on law enforcement officer. I found PC. I found it for disorderly intoxication. I even found it for resisting officer with violence. Okay, pushed a man, whatever. Okay, I had bond set at like 1,000 across the board. Well, 1,000 for the battery, 25 for the disorderly conduct, and 1,000 for resisting with violence, which is pretty low. Here's the question, Mr. Pryor: was this man at all, to your knowledge, involved in any type of lewd lascivious?
Not to my knowledge, Your Honor. My only
All
knowledge
right.
is based on a PC, Your Honor.
All righty. Now you found my PC finding. What is the state asking that I do?
Your Honor, based on the facts and what was presented to me, there is obviously a mental health issue because it's being raised by defense counsel and the defendant's family. I wouldn't object to him being placed on a pretrial situation, but it's going to have to be some monitoring with the pretrial, and I'll defer to the court as to the conditions of pretrial. If he has an address, if he has somewhere to live. But I wouldn't object to that based on the facts that have been given to me by defense.
And Your Honor, just for PCR, my understanding that you've already found PC for the 3 counts that he's being charged with. I would be objecting to any type of intent or knowledge element based off of the intellectual disability that was presented before the court. You have to know, at least for background, it's a specific intent crime. So you have to have the intent to commit that on the officers, and based off of the knowledge that I've received about this individual, I don't think that he even has a requisite functioning to be able to
And Your Honor,
create those, I guess, knowledge issues or because of his intellectual disability.
Your Honor, respectfully, Harold Brown, Baptist State of Florida, this is not the proper venue to establish that based on the facts that we haven't established officially on the record, and the state has not stipulated to, nor are we going to in this venue or at this juncture, that he is mentally incapacitated or incompetent to proceed. So based on that, Your Honor, and based on the probable cause affidavit, it's the state's argument and contention that there is probable cause to go forward, and that this is not the proper venue to make that determination whether or not he had intent or knowledge going forward. And be honest with Your Honor, that is for the trier of fact or to be determined by a judge that this case is assigned to, if in fact the motion to suppress or motion to dismiss is filed by the defendant.
All right.
My turn, Judge. Well, Mr. Percenti is telling me he has a job he's been working at for 2 years. He doesn't have money to bond himself out. He'll be asking his mother to do that for him. He's been here since 1998, does have those strong family ties, a job. Judge, you have the authority, if you wish, to order him to pretrial, and as a condition of release, to have him check in with Henderson or another mental health provider, get a screen, follow any recommended treatment going forward. And if that's what the court wishes to do, I would ask that we waive any monetary conditions to the bond.
So Your Honor knows he works at the special needs school. The school he goes to is all encompassed. So it's not like he has a side job.
You don't have a job.
Mom, where are you from?
The Bahamas.
Wait, I won't tell nobody that. What part?
I'm from Harbor Island.
But they got Freeport and Nassau.
Yeah.
I can never afford to go to Nassau, so I take my wife to Freeport every 4 or 5 years. You been to Freeport before?
Oh, yes, I have.
Yeah, I took her to Freeport. She, I want to go to Nassau. We ain't got the money, I tell her.
I'm from Harbor Island, a small island off Eleuthera, where the pink sign is.
Yeah.
Yes, I am. Could I say something, Judge?
Yeah. I'm going to give your boy back to you, okay?
I appreciate
I'm going to
that.
put him on just pretrial release, okay?
Yes, sir.
Let me lay a record. Defense, I understand your arguments, but I was on the adult court. I found out that you can't deviate a case because of intent. Intent always goes to the ultimate fact finder. But I also find out that PC is not the place for a judge to be looking at PC saying that I don't feel that there's any intent. I'm going to go ahead. Intent is later on for the fact finder to resolve what his intentions were. It's not for me at this stage to look at a police report and conclude and basically look at the documents that there was no intent. And that's the only issue for me is there probable cause, likely more than not. And whether he had the intent is for another judge, another fact finder to weigh the evidence as to whether he had the actual intent. So you got him, okay? Mom, so go pick him up. It's going to be on pre-trial. I need you to keep working and going to school. And for the record, the defendant can't really comprehend or understand, or he's not speaking, and the cousin says that because of his serious disabilities. State, make sure that somebody look at this thing on in case filing, okay?
Yes, Your Honor.
Make sure they get this kind of all of it. Yeah, because this is the kind of case a man ain't done nothing walking down the street. He's got issues. And a cop come up there. Bachelor, you need to get this stuff, not you, but somebody get this over to the fact file.
Yeah.
I can't speak to him.
Okay.
Yes, I can't put it all on paper.
No, your name, your address, and your telephone number. Name, address, and telephone number.
Yeah, it's just going to be pre-trial without any monitoring. I don't know if you need to get any monitoring prior. It's just pre-trial. Pre-trial, watch him, okay? Guy's trying to do his best.
Henry, the candle?
Judge Robinson. Okay. Oh, you want me to?
No, what the mental health stuff, so they know if.
You understand what I'm saying? I understand what I'm saying. They need to give it to the attorney that he's assigned to.
Yeah, right. Yeah.
I already spoke to him about it.
Oh, okay.
That's right.
Where's Dolores Gates at? Gates!
North Broward, Your Honor,
Broward.
North Broward Judge, and
That's
we
it.
have
You're
an
done.
argument.
Thank you. Thank you.
Do me a favor.
Okay, Your Honor,
I'll
the
just
family's
say,
asking, once he's released, is it possible that there can be an order in place that maybe an armed deputy or deputy stays with him till the family comes, because they don't want him wandering?
let's go back to him. Where's he at? Main jail?
He's at main jail, Your Honor, their family's gonna come get him.
Miller, bring the last guy back up.
Yes,
Mr. Rayfield. Let me have a look. Conversation. Let me make sure we talk.
Presenti, released to the custody of mother? Okay. Just give an order, I'll do the order right now.
Miller, his name is Kyle Presenti. Okay, let me have the guard who's standing there with you, Miller. Does it a jail guard? Deputy, how are you doing, sir?
I'm doing fine, Your Honor. How you doing?
All right, pretty good. My name is Judge Williams. How long you been working there? At the sheriff's office?
A little over 15 years.
15 years?
Yes, sir.
I used to be the sheriff's lawyer there. I used to be y'all top lawyer there 13 years ago. So you was just coming in when I was there.
Yes, sir.
Y'all do a good job, but I need you to do me a favor.
What's that, sir?
I'm going to sign an order. He's got some serious mental disabilities. He being the guy to your right, Mr. Presenti. He can't even communicate, okay? He's got an IQ very low, okay? I don't want him released out on the streets so he walks up down the street and hit by a car. I'm going to issue an order that he is not to be released to anyone but his mother, okay? He's going to go on pre-trial, but I don't want somebody just saying, okay, man, it's 2 o'clock in the afternoon, you're free to go, and he gets hit by a car, okay? So I want somebody to hold him there till his mother comes to get him, okay?
Sounds good, Your Honor.
Yeah, let confinement status know. I appreciate it.
We will do that.
Okay, thank you so much, Deputy. All right, thank you.
Yes, sir.
Thank you.
Hey, back to me, something right.
Thank you.
Thank y'all so much. We'll see y'all.
Thank you.
Gates, where are you, Dolores?
Yes, right here.
Dolores, you got a no bond hold. Ain't nothing I can do for you. Good luck.
Defense has an argument, Your Honor.
Go ahead.
In Mrs. Dolores' case specifically, there is no PC for a Berg battery. In this particular case, Your Honor, and I'll outline the reason why there's no PC. There's several reasons. On the authorization to be inside the vehicle, there is nothing that says that her entry was unlawful. They've been together, her and her partner have been together for 16 years. There's nothing saying that the ownership of the vehicle is also at issue. Who's to say she doesn't own the vehicle? Who's to say they don't own it jointly? And who's to say she wasn't invited in the vehicle at any time, or that she's licensed or has permission? Understanding this is a battery arm, I definitely concede to the battery being PC and upper battery, but Berg bat, I don't find PC, Your Honor.
Your Honor, Harold Brown on behalf of the state of Florida.
One second, Mr. Brown. Bachelor, are you finished with your argument?
Yes, my argument.
Go ahead, Mr. Brown.
I apologize, Your Honor. If you look at the PC a little bit further, it says that there was a dispute. They're in verbal altercation, and it says that he attempted to separate himself from Gates and the situation. He entered his vehicle and then backed out her driveway, and she entered in the passenger side to strike him. Your Honor, my reading of the probable cause affidavit, he's trying to leave that situation and get out of there, and she jumped in and wanted to keep it going. So based on that, Your Honor, there's probable cause.
For burglary, Your Honor, there has to be an unlawful entry, and since there is no unlawful entry at this point, and there's nothing that states 2 people could live in a house together, one person decides to walk outside the front of the door, and then the other person decides, or go into the home, and then the other person decides to stay out, and then go into the home at a later time and continue the argument. It's still not a burglary for them to enter their own home. It has to be unlawful entry for a burglary.
I can't talk. I can't talk.
Yeah, you right
Sir.
there.
Miss Gates, please, at this time, let the judge.
Yeah, Gates, let me finish reading this thing. I'm 56. I don't read it once early this morning, but I'm getting old. Let me read it again, okay? Hold on. What was he arguing about, Bachelor? Do you know?
Judge, when you're finished.
Yeah, go ahead. Bachelor, what were they arguing about?
Judge, I just wanted to point out to the court
Yeah, go ahead.
that according to the
Miller, let me
probable
come back. Let me
cause
look at your face,
affidavit.
Miller. Go ahead, sir. I'm sorry. Go ahead.
Hi. According to the probable cause affidavit, the vehicle in question belongs to the defendant. According to the probable cause affidavit, if you look, it says the Dodge 03 1997 with that tag number that's mentioned in the write-up. It's listed as the defendant's vehicle.
And Your Honor, it's my
Well, where did you get that from? I'm looking at mine, sir. It says he entered his vehicle.
I understand, Judge, but if you look at on the probable cause affidavit just above where the charges are written, you'll see that it has a defendant's vehicle make. It says Dodge 03, type 03, year 1997, red, and then it has a tag number. That tag number matches the vehicle that's in the write-up. And so the police are saying that this vehicle belongs to the defendant. And so on the face of this probable cause affidavit, there cannot be a burglary because the vehicle belongs to the defendant. You cannot burglarize your own vehicle.
that. Your Honor,
There's
that's
enough
not
case law to say you can burglarize your own vehicle. I can find five
Right.
different examples under the state statute on that. You can burglarize your own vehicle.
Harold
You can
Brown Baptist
burglarize
State
your
of
own
Florida.
house. But go ahead, Mr. Pryor.
Right, Harold Brown Baptist State of Florida. I believe there's
Yeah.
case law on that.
Okay, here's my sense. Again, Bachelor, do you have any clue as to what they were arguing about?
It's Valentine's Day today. There's a lot that people may argue pre any holiday. So I can't say it was about the light bill. I can't say it was about grandchildren. I don't know what it was, but as for the burglary, I'm focused, and I understand Your Honor does want an answer to this question. I don't have an answer.
Yeah, so they were fighting over who owned the truck. It's a burglary with the battery because they're fighting over who owns the truck. So I don't know what the argument is about. But if they're fighting over something like who's paying for dinner tonight, that's a whole different argument, which doesn't inure. If they're fighting over the actual truck, it is a burglary over battery.
And we don't have that information. Your
Yeah, we
Honor.
have the information. That's
It
what's
has-
throwing me off.
It has to lean towards the defendant's favor, Your Honor. Being that we don't have that information and it's not in the probable cause affidavit, it would have to be determined in the defendant's favor.
All right. Let me go back to her. Gates, are you working?
Sir, I've been on my job 15 long years. I have never
Well,
been
hold on
in
a second. How is
trouble.
it 15 long years? I've been a judge for 14 years. It ain't 14 long years. Where you been working at 15 long years? Where you
At
been working
Memorial
at?
Regional Hospital in Hollywood.
What do you do for Memorial?
I'm environmental tech.
Okay. My wife is a hospital administrator. When you say environmental care, that could be cleaning up the hospital. Is that what you do?
Yes, sir.
And when was the last time you was at work?
The day's supposed to be my day to work. I work Friday, Saturday, and today's supposed to be today I'm supposed to work.
So when you clean them rooms, you use all them chemicals to keep them rooms like disinfected and stuff?
Yes, sir.
Are you working the night shift or the day shift?
Day shift.
Raise your hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, except your God?
Yes, sir.
All righty. Now, this guy you so-called allegedly fighting with, David McCoy, are you in love with him or can you stay away from him?
Yes, sir.
Can you stay away from him?
Yes, sir.
All right.
Can I say something, Your Honor?
No, go ahead. Let's talk about the facts of the case, but go ahead.
Do not
Right.
discuss the facts
no,
of your
we
case,
have
ma'am.
a child
You are
between-
under oath.
We have a child between each other, a daughter, and we've been together for 16 long years.
Everything is always wrong with you. 15 long years, 16 long years. Go ahead, ma'am. Okay.
16 years, and we have a daughter between each other.
All right.
So it kind of got out of hand.
Ms. Gates, you don't need to provide any other information. Do not talk about the facts of your case.
I tell you what I'll do. I'm going to go ahead. listen to me a second. I just have to get a feel for you, okay? You're at the
Yes,
hospital. You
sir.
clean those rooms and keep them all disinfected so I don't pick up something whenever I go to the hospital. I'm going to go ahead. Prior, you guys can make this a burglary of a battery and y'all go ahead and y'all file it. That's none of my business right now.
Right.
I'm trying to get a sense of the case. I'm just going to find it for misdemeanor battery, all right, at this stage. And I'm just going to go ahead and set your bond. How much money? Can you bond out with $100?
Yes, sir.
I'm gonna make your bond $100. I'm gonna put you on pretrial release. Pretrial, keep an eye on her. You need to get back to that job. Yeah, it's gonna be pretrial release, misdemeanor battery. I find PC for her. I need you to stay away from David. Does he have the daughter right now while you here? Where's your daughter at? Your mama house, or where's the daughter at?
I'm not sure. They didn't allow me a phone call to find out. I don't know.
Okay, I thought they let you make phone calls. They don't stop there giving you a dime, huh?
I haven't gotten a phone call yet.
All right, I need to talk with the sheriff on that. I thought they get a right to a phone call. Thatcher, I thought you get a phone call when you get in there. Everybody keep on getting.
A lot of them have complained that they have not.
You get a dime, you get a phone call. Everybody know you get one call. I need to speak with someone. Okay, I'm gonna go ahead. So, misdemeanor battery, $100. Just post bond for $100, but I'm just gonna put you on a regular pretrial. Okay? You just gotta go back to work. Okay? And I need you to have.
Yes, sir. Thank you.
Don't have any contact with David McCoy until we get this resolved. Okay?
Yes, sir. Thank you so much.
Now ask me how long have I been married? Ask me.
How long? How long have you been married?
21 long years. It's always long. Take care of yourself.
Thank you.
Tiffany Miller, where's Miller at?
I'm over here, Judge.
Where's she at?
I'm in the main jail.
Judge.
Tiffany. Girl, you got a no bond hold for a probation violation. I can't do
Judge,
nothing
I
about
cannot
that. Do you
figure out-
understand? I can't help you out on that, but I will go ahead. It's $500 bond for criminal mischief, the disorderly conduct. I'm going to set it at 500, and resisting is going to be set at 500. Good luck.
Judge,
Yeah, go
Judge,
ahead, Mr.
before we
Miller.
turn the page on Miss Miller, I
Yes, sir.
cannot, in reading this probable cause affidavit, figure out why they were arresting this poor girl in the first place. There's nothing to indicate why she was being detained, what the official duties that the officer were performing at the time of the detention. There's just nothing there, Judge. The court has, I think, in its discretion to not hold her no bond, to give her a bond on count 4. It's a 948 hold, but I believe you have the discretion to give her a bond. I think under the circumstances, I would ask the court to consider doing that.
Your Honor, Harold Brownbass, State of Florida. My reading of the probable cause affidavit, you look at the top of it, although there were no particulars as to state why, it says that they were dispatched to above address in reference to a disturbance. Your Honor, based on that probable cause affidavit, they were lawfully there. They were performing their duties as law enforcement officers to keep and enforce the peace, and they were on the scene. And the defendant, she illegally obstructed their lawful duties as law enforcement officers, and she was acting disorderly on that day. So based on that, Your Honor, state's argument and contention that there is probable cause because they were lawfully there. They were called in legal executionary duty to the scene. They were dispatched there in reference to a disturbance.
And Judge, I'm not arguing probable cause. I'm just simply stating that in the totality of the circumstances that I don't know why they were arresting her in the first place. I think that they've stated a cause of action after she was arrested that would rise to probable cause. But under the circumstances, I would ask the court to consider go ahead and release her pre-trial, get her a mental health screen, and let's see if we can get this woman some help.
Mr. Miller, she's got an extensive record. If this is her record,
I'm sorry, I'm thinking about this girl.
it's quite extensive.
Yeah.
If I'm reading it correctly.
Everything else?
I do find PC, as stated. Who's the probation violation? Is she on community control or probation with someone?
She's on probation, Your Honor. The court, it's in front of Judge Porter. It's
Porter's
a felony.
got her?
Yes, Your Honor.
What's the charge?
Resisting with violence, battery on a law enforcement officer, DUI, property damage. and leaving the scene of an accident.
I understand your argument, Mr. Miller. It's a no bond hold. I'm going to go ahead and hold her on that probation violation. She needs to go see her judge. And it's going to be set at $500 on criminal mischief. Instead of $500 on the disorderly conduct, you can just go ahead and RR on that. And resisting without violence, you can just go ahead and make that $100 instead of $500. So $100 on the resisting, a no bond on the probation violation, 25 on disorderly conduct, and just keep the 500 on the criminal mischief. All right, where's Michael Bruno?
And
Bruno.
Judge, before you turn the page, can we get a mental health screen for Miss?
Yeah, we'll go ahead and get a mental health screen on her. Thank you, Mr. Muller. I need to get a mental health screen on her too. I'll slow down for you, clerk.
Go back where you were. Good luck. Bruno. Judge, we have an argument for Mr. Bruno as to count 2.
There's a microwave. Where you got? Yeah, I don't know where he went. He said, Judge, I find it. He came back in like 2 minutes. You can't now. Don't walk too far. I don't get you in trouble. Yeah. No. That call. Yeah. 2 minutes. All right. Bruno, is that you, sir?
Yes, sir. It's me. Main jail judge. We have an argument.
Okay. Bruno, I found that you at that Dandy Donuts. I've never been to a Dandy Donuts.
Pretty good, Your Honor.
It is?
Yeah.
I only heard of I go to Krispy Kreme and I went to Dunkin' a couple times. All right, but I'm going to go ahead. I do find proper cause. You were drunk as a skunk, they say, so it's $100 for drunken intoxication, and I got $100 for resisting without violence and $100 for trespassing. I'm going to tell you not to return back to that Dandy Donuts. So you got yourself $200 in bond. What are your thoughts on that, State?
State defers to the court.
All right, what's your thoughts, Mr. Miller?
Judge, I believe that there's no probable cause for resisting, approaching an officer in a threatening manner. I don't believe is resisting arrest, and that's the only thing that's outlined in this probable cause affidavit that would rise to the level of or that would address the issue of resisting. With that said, Mr. Bruno would like to resolve these cases, these charges, if the court is so inclined.
Bruno, how can I get you to go? How can I get you to stay away from that Dandy Donuts? Are the donuts that good? So I need you to stay away from that. Do you understand?
Yes, sir.
All right, Miller. I think you're right. Miller, I think you're right. I'm not going to find PC on the resisting without violence. As I look at it again, I see what you're saying. But it is on a disorderly intoxication. It's $100. No PC on the resisting, but on the trespass, I'm just going to make it $25. Okay. I'm going to go ahead. So, can you post bond, Bruno?
Yes, sir.
Bruno, let me ask you something. Are you homeless, sir?
Sir, right now I'm relocating. I'm really reinstating my my future right now. I'm starting to work with a job. I was introduced and applied. I was accepted. On Tuesday, I'm supposed to report for a job, and another was supposed to come up on me.
Bruno,
and
wait,
I was actually,
are you homeless?
Yes, sir.
Are you?
Temporarily, yes.
I need
2 weeks federal notice.
I'm struggling with it, Miller. I'm just trying to. Can you post a $100 bond, Bruno?
No, sir. I like this. Leave.
What's your thoughts, Miller? I don't know if I can resolve this outright on a disorderly and a trespass. Can I, Mr. Miller? Can I state?
Judge, I have seen all 3 of these resolved in bond court.
Well, I'm not going to find PC on the resisting without violence. I think your argument is mirrored. In terms of regarding the disorderly intoxication and trespass, in a lot of the point, the state has an opportunity to perfect on count 2.
Correct.
Should I resolve the case, Mr. Pryor? Because otherwise, I'll be resolving 2 counts, and the state's got another count hanging out there.
Yes, Your Honor.
That's my concern. What's your position, Mr. Pryor?
That would be my concern as well, Judge.
Your Honor, the state would ask for at least 24 hours to perfect, Your Honor.
I'm going to say 24 hours to perfect. Bruno, I need you to stay overnight because I don't want to go ahead and put you in a worse pickle than you're already in. So stay overnight, and I'm going to give the state time to perfect on count number 2. Good luck, sir. There'll be another judge tomorrow.
Thank you, Your Honor.
And Judge, for the record,
yeah,
it's my understanding that the folks at Dandy Donuts watch the live stream of this bond court on a regular basis.
Who does?
The folks at Dandy Donuts.
Sir, may
They
I
do.
make a statement?
I'm going to go visit. By the way, where is that Dandy Donuts at, Mr. Miller? What city is it in?
On Hollywood. The one I'm talking about is at Hollywood Boulevard, just east of I-95.
Yeah.
Right across from the,
Okay,
right next
I'm
to the
going to visit. Like I said, I want to
There's
go
one
to
in
Krispy
Pompano,
Kreme.
Judge.
I want to go to Krispy Kreme. What do you got there, ma'am? Thank you, Mr. Bruno. Good luck. What do you want?
So 100 on the first count, 25 on the third count? No PC for the second.
Right. I'm
And the
gonna be
state
inclined to resolve it, but I don't wanna resolve it and have them come back and file.
and the
So,
state's requested 24 hours to
yeah,
perfect.
bring it back 24 hours.
And are you using the $100 bond on count two, Judge?
No. Count number 2, I'm just gonna go ahead and, that's gonna be no PC, because I'm giving them time to perfect. So it's gonna be no PC on count 2, but they've asked for 48 hours, 24 hours to perfect. I thought you give 48 hours, Mr. Pryor, up to 72.
Correct, Your Honor. I just
So make
have
it
the
48 hours.
48 hours. Thank you, Your Honor.
Actually, Your Honor, my reading of the laws, they have 24 hours. I don't know where this up to 72 came from.
No, there's no bond on count 2 because it has to be perfected. I can't set a bond for something that hasn't been perfected.
Understood, Judge.
I'm trying to
I think
go
that's
PC, but I'm gonna give them time, so it's gonna be 0 bond on count 2. Tomorrow, if they come back, clerk, they can go ahead and perfect it, and I'll set a bond in, okay?
We ask for 48 hours, Your Honor.
48 hours, give me 48 hours. Yes, 48 hours up to 72.
And Your Honor, I think Mr. Miller was asking what statute that state has 72 hours to the fact.
Mr. Miller, off the top of my head, it's my understanding that the state, I looked at the rules about a couple years ago, the state can have up to 72 hours to perfect, but I thought it said the initial is 48 hours, they can get an additional 24 if they state a reason. Can you hear me, sir?
Yes, Judge. I'm gonna.
Yeah, Mr. Miller, look under, I think it's up to 72 hours. Yeah. Yeah, they get the initial 48, but it says up to 72 hours. If they need like an additional 24, they can come back and, see the officers in the hospital and so forth.
One moment, Judge.
Mr. Miller, take a look at that while I step for a second into the gentleman's room. Court's in recess for about 30 seconds.
Yes, Judge.
No, I don't. I know it's 48 hours. I misspoke. It's 40. I said 24.
Do you have a statute state or going off the rules of procedure?
It's rules of procedure, I believe.
I believe that too. Thank you.
Oh.
We got to call him White, tell him he gonna be late.
Can't do that. They have this lady no bond hold on a bird bat. They can't do that.
I know, right?
Where's the last one we stopped at? I won't make it short.
Stuff that we know we're going on.
Okay, yeah.
I think that day off tomorrow.
Tomorrow's a DSO holiday, right?
Come to order, court is back in session.
All righty. Mr. Miller, was I right or was I wrong, sir?
Well, Judge, I have a different take on this.
Oh, I'm second, sir. Mr. Miller, the state's not here right now. Hold on, Mr. Miller. My state also must have... Give me 1 second, sir.
Yes, sir. I'm looking at 3.1.
Mr. Miller, I'm sorry, sir. My state attorney left the courtroom. Can you hold on a minute? Yeah, I want ex parte. Hold on.
I'm just telling the court the rule we're looking at.
Okay. Okay, Mr. Pryor is back with us. Go ahead, Mr. Miller. I'm sorry. What's the rule, sir?
3.133
What does it
cause
say?
determination. Judge, my understanding is that the defendant is required to be brought to court within 48 hours of his arrest. And then the court can continue for 24 hours upon showing of extraordinary circumstances, and then continue an additional 24 hours. So my argument would be that the bringing of the defendant within the 48-hour period starts the clock for the next 24 hours. So if the court wants to extend to the state for an extraordinary reason, 24 hours to perfect the probable cause affidavit, then that would be within Rule 3.133, and then the court could give them an additional 24 hours. But my reading of the rule is the court, once the defendant is brought, can continue the proceeding up to 24 hours, and then, if necessary, continue it 24 hours again.
Okay, hold on, Mr. Miller. Prior.
That's my understanding of that.
All right, so learned hand, Mr. Miller, learned hand has just spoken. You concur?
I concur, and based on that, Your Honor, and based on the circumstances,
Bruno comes back in 24.
48 hours. I'm requesting that it be 48 hours. Based on the facts, we're asking for an extra 24 to make that happen. Based on the fact that it's a weekend, and also my reading of the probable cause affidavit.
So, Mr. Miller, so I don't misinterpret your position. Are you saying that Bruno has to be brought back tomorrow instead of on Tuesday?
Judge, that would be my position, yes.
Yeah, but based on it, the court has the discretion on Rule 3.1330.
A discretion to make it 40 hours.
Your Honor.
That's what I thought, Mr. Miller. I can make it discretionary at 48.
3.130? I don't think that's applicable.
So we
once first appearance is
right. But I'm requesting 48 hours, Your Honor, because it'll probably get done. It could get done before then, but it's standard procedure.
But can I just send it tomorrow and then the state can request another 24?
That's fine. Your Honor.
I can do it that way, but my concern, Mr. Miller, is quite frankly, I'm not so sure that the state's going to be able to perfect that charge, putting up your hands and so forth. But however, I can't,
Your Honor, I mean, in light of what's been happening in this magistrate court for years, there's been 48-hour extension. So I don't know.
It's always been 40 hours.
I don't know what the posture is today, but if they want to do that, that's fine.
I'll do 24. If the state wants to come back in 24 and make an additional 24, that's fine. You can just set Bruno for tomorrow.
Right.
But it's always been 40 hours.
Yeah.
I've never heard of
Judge,
that
can I
before.
read the sentence into the record so that the court knows what I'm talking about here?
Yeah.
Okay. The judge, after showing of extraordinary circumstances, may continue the proceeding for not more than 24 hours beyond the 48-hour period. My argument is that once we bring him to court, the court now has the ability to extend for 24 hours. I understand that this court has historically extended 48 hours, but I don't believe that that's what the rule says. I believe the rule says that once you bring him to court, you can give the state an extra day. And then if they still need another day, that second 24 hours, you can do it again.
Well,
you can't go beyond that.
And so in light of that, of the criminal rules of procedure, Your Honor, I'm requesting 48 hours. I believe that we're going to need an extra day. So the state is actually making that formal request now for 48 days. And you have the discretion to grant that 48 days. 48 hours. Sorry,
I
disagree.
disagree.
Hours.
I've been...
Yeah, that's my understanding of the law, is that I can always just say up to 48 hours, but I'll go ahead. I'll give him 24, and you can just ask for another 24 tomorrow. It's not a problem.
That's
I'll
fine.
give him 24, ask for another 24 tomorrow. But
Judge, I appreciate you giving him 24 because it's my hope that he can come tomorrow. We can go ahead and resolve this case.
I agree with you on
And he
that.
can start his job on Tuesday.
Correct. Yeah.
And Mr. Miller, again,
Yes, sir.
I agree with you on that, your assessment of the situation. Because if he's not working, then we back to Dandy Donuts. You know what I mean? And he needs to get a job and get off the streets and get someplace to go. I mean, a working man goes in those donut shops, gets out, and go to work. That's what you need to do. So at this point in time, where's Travis Wilson at tomorrow? Travis, where are you?
This is Mr. Wilson, Judge.
Travis, they got you on Facebook. I do find probable cause that there's a violation of an injunction against domestic violence. I set the bond at $7,500. Allegedly, you confessed that you did indeed try and use someone's name. I don't want to say Jim Bob, Greg Bob. So again, I'm going to set bond at $7,500. You got to move on and find yourself another woman, okay? A lot of fish in the sea. You understand, Travis?
And Your Honor, we'd ask no contact.
No contact with the girl.
Lynn Head.
The lady. I'm sorry.
And Your Honor, there was a prior battery case in 2014 that was disposed between him and the same victim in that case. It was actually disposed of. Actually, he was arrested for it, but it was no info. But I was just putting that information out, so never mind that, Your Honor.
The 7,500. Stay away from that young lady. And by the way, her name is what?
Lynn Head.
Brittany Lynn Head. Stay away from her, okay? Find yourself another one. A lot of fish in the sea, okay? Good luck, sir. Where's O'Shane
Good luck to
McFarland?
you, sir.
O'Shane, where are you?
He's present at the main jail. He would like to resolve this trespassing case if he can.
O'Shane, you got yourself sitting there on a trespass. At this point in time, sir, do you want to resolve it or you want to fight it? I do find
You
probable
want to fight it or
cause
resolve it?
for trespass. You want to
You
resolve
say.
it?
He wants to resolve it, Judge.
All right, now, I can't have you go back out there at that house because it's cold at night. You understand?
Speak to the judge now.
I can't have you go back out to that house. Do you understand, sir?
Say yes or no.
So where are you going to stay when you get cold? You're not going to go back out there, are you?
He's asking you, are you going to go back there?
Miller, does he seem to understand what's going on, sir?
Judge, I think he's following my advice. I've advised all my potential clients not to speak when they get to the podium, so I think I've put the fear of God into him, Judge, and now I can't get it out.
All right, yeah, because if he's going to take a plea, he's got to talk to me, okay?
Yes, sir. You
In
can talk to the
Russia,
judge, okay?
raise your hand, sir. Do you swear to tell the truth, the whole truth, and nothing but the truth? Okay, you got both hands up. Put that left hand down. Put your right hand up, sir. Do you swear to tell the truth, the whole truth, and nothing but the God-given truth, except your God?
I swear.
All right, you charge of trespassing. Put your hand down. Now, do you want to resolve the case?
Say yes.
Yes, Your Honor.
Are you on that dope?
No, Your Honor.
Any alcohol in you?
No, Your Honor.
All righty. Now, at this point, do you understand that you've got the right to fight the charge? You understand you've got the right to fight the charge?
Yes, Your Honor.
You can't go back out to that residence anymore. Do you understand?
Yes, Your Honor.
So when it get cold at night, where are you going to go?
From
Where are you going to go?
family.
Where did he say?
His family, Judge.
Your family will find your girlfriend. You understand?
Yes, Your Honor.
I was out in the cold until I found me a girlfriend. Do you understand?
Yes, Your Honor.
All right.
Your
At this
Honor,
I
point,
will find my girlfriend.
go ahead, Mr. Pryor.
Your Honor, we ask that it be no return. Or
Don't
no
return to that
contact.
property. You understand? Find some other place.
Right.
Go ahead, Mr. Pryor.
Yeah, no return to that address, which is 3.
Don't go back to that address. Do you understand, sir?
Yes,
What is
Your
your plea? Guilty, not guilty, no contest. McFarland, O'Shane, what's your plea? Guilty, not guilty, no contest.
No contest.
All righty. At this point in time, O'Shane, I'm going to go ahead and just adjudicate you time served. O'Shane, are you still working at the Caribbean Kitchen?
Do you still work at the Caribbean Kitchen?
I have a different job. I have numerous. I've got a lot of jobs. And I do automotive.
All right. It's adjudication time served and it's simple trespass. All right, good luck. Where's William Little
Thank
at?
you, Judge. Off you go. Good
Yeah,
luck.
court calls.
He's present at the main jail, Judge?
Thank you, be court calls. On William Little,
Yes, sir.
It's a violation. of
looks
probation.
like Judge Lerner Wren is looking for you. You got a no bond hold. I can't help you out. Go see Judge Lerner Wren. Thank you, sir. Good luck. I can't help you out,
Thanks,
sir.
Judge.
Where is Daniel Jenkins?
North Broward.
It's a municipal ordinance, Your Honor.
Yeah, on that municipal ordinance, it's for what city? It's got a capio set for no show, and it's set for $100.
I believe it's Pompano Beach, Your Honor.
It's Pompano Beach, $100 capios. You got to post bond, sir. All righty?
All right.
Thank you. Where's Paul Staple?
Judge, he's present at the main jail. This is a Hollywood case, but Mr. Staple has advised me he would like to resolve this case if he can.
It's a no-show capios. Bond is set at $100.
Your Honor,
Yes, sir, ma'am.
sorry, can we go back to Jenkins? Is there any way to reduce the bond from $100 to $25 in municipal?
Let's go back to this case. Which case is
All
that?
right, Jenkins, the last case we just called up.
Jenkins, where is Jenkins?
In North Broward, Your Honor.
Hold on. Jenkins, is that you?
We're getting him now.
You what now?
We're getting him.
All right, thank you, sir.
Present, Your Honor.
Okay, thank you, Mr. Pryor.
Yes, Your Honor.
Yeah, Miss Batchelor is asking me to reduce that capious
It's a municipal ordinance. I don't think it's.
from 100 down to. I don't think I can reduce it, can I?
No, I believe you can, but it's a city case. It's not a state case. Yeah.
You can ROR him too, Your Honor.
Yeah, it's a city case, Your Honor.
What's this charge? No lodge on city on. What's no lodge? What does that mean?
I think he was just sleeping on city premises.
That's what I mean?
Yeah.
So if I sleep, okay. Hey, Pryor, one day I was at the library doing research a couple years ago. I just thought for like a minute because I've been doing a lot of research. The cop came along and said, I'm gonna have to arrest you. You can't sleep in the library. I went off, you know what I mean? Because I'm thinking about something. I just want to lay down for like 3 seconds just because I'm arresting. And he said, well, we can't have anybody sleeping in the library. So, okay, Daniel, is that you?
Yes, sir.
Daniel, I'm just gonna go ahead and knock your capious from $100 down to 25. Post it if you can. If not, take it back before a judge, okay? All right?
All right.
All right, it's down to 25. Where's Paul Staple?
Yes, sir.
No, she's president of Maine.
Staple, you owe me
And
$100 in order for you to get out of there, sir. At this point in time, you got to carry an open container in public. All righty, do you understand?
Yes, sir.
Staple, you need to go ahead. It's headed $100. You didn't show up at your at a court hearing. You need to show up. Do you understand?
Yes, sir.
It's at 400. Thank you. Where's Aquiles Pena?
Judge, you don't want to resolve the case?
Paul, what kind of beer? I can't ask you whether he was allegedly drinking an American beer or a foreign beer, Mel. I don't know what he was even. Was it a beer?
Naturalized, Judge.
Naturalized.
That's an American beer.
Yes, sir.
All right. I'm going to go ahead. It's going to be 25 instead of 100. Do you understand?
Yes, sir.
So go ahead and post that and get on out of there. You understand? And it's $25. You understand?
I have no money. I'm homeless. There's no way I can post it.
Bring it back to another judge tomorrow, Tuesday, okay? And see if he'll take it. But right now it's 25, okay? Thank you.
Yes,
Where's
sir.
Aquiles Pena?
He's here at the main jail, Judge.
All right, he's at the main jail. I've got a capious set for $500, Aquiles. At this point in time, allegedly it's for driving with license suspended. At this point in time, you need to go ahead and post your capious. I'm not inclined to reduce that or work that out. Thank you. Keep moving. Where's Faustino Vasquez?
He's here at the main jail, Judge.
All righty, Vasquez, you got capiouses for $100 and $500, sir. You missed an arraignment, sir. I don't know what to tell you. You need to go ahead and post those capious amounts. Thank you. I'm done with it. Not inclined to reduce that or move that. Where's John Barnes?
Okay. Good luck. He's here at the main jail. He's declined the PD.
You're at the Quiet Waters Park, allegedly, sir.
Yes, sir.
Cussing, fighting. You end up striking the security man at the park or whatever on the right side of his face and ear. The man was bleeding from his left ear. At this point, you tried to allegedly kick other security people. I'm going to go ahead. Your bond is set at $1,000. It'll remain. It's set at $1,000. Good luck, sir. No return to Quiet Waters Park until we get this resolved. Where's Wayne Petroselli?
He's here at the main jail, Judge. He's
Wayne, where are
resolving
you?
this trespassing case if you the court's so inclined.
Wayne, allegedly you're at a 7-Eleven, sir, over there at Seabreeze. At that point, you have a trespassing bond of $25. You need to stay away from there, sir. The man says that allegedly he's told you to stay away, so I'm going to go on numerous occasions to stay off the property. I know exactly where that place is. That's why I stopped to get me a drink when I'm at the beach. So again, stay away from there. It's $25. Post it. Thank you. Where's Alfred Pryor? Is he related to you, Mr. Pryor?
No relation, I don't believe.
Pryor.
Okay, we'll be back in a couple of days.
Where's Alfred Pryor?
Judge, Mr. Pryor is president of the main jail. Mr. Pryor, come on up. Judge, I believe Mr. Pryor is one of yours.
Pryor, I was going to say I know you. They got you at a church carnival, Pryor, allegedly smoking marijuana. Pryor, do you remember me, don't you? Yeah, you remember me, Pryor. You got a no bond hold because you're on probation. Miller, this thing is all messed up. Who is he on probation in front of, sir?
You.
Right, so on my probation, he has a no bond hold.
That's the 948 kicking in, Judge.
All right, so you got a no bond hold in front of me. And Pryor, why do I have you on probation, sir? I'm getting old.
What's the charge?
Mr. Pryor, Harold,
Yes, Your Honor.
What is your my probation for? Pryor, what's the charge you're on probation for?
Burglary.
All right. How long you been on probation? What month and what year?
Since last year. What month? May.
A long time to be on probation, Judge. You get them till they're 21?
Yeah, until he's 21.
Judge, I was going to ask the court, since this is your case, if you could go ahead and ROR him on count 2, let him get to school on Monday. He's supposed to graduate in June, but he's not going to be able to do that if he's not in school.
What school you go to, Pryor?
Mavericks, huh?
Which one?
Mavericks.
All right. Richard Pryor's not your daddy, is he?
No, sir.
I met Richard Pryor once. Alfred.
Yes, sir.
Alfred.
Yes, sir.
I'm gonna go ahead and release you on your own reconnaissance. There's no bond hold. That's gonna be me. He belongs to me.
Okay.
You need to post $100 on this cannabis count. They got you smoking reefer at a Catholic church carnival. Okay? Pryor, you don't go to the carnival at a Catholic church for nothing. Do you understand, sir? Except to like win a teddy bear for your girlfriend, eat cotton candy. You understand? Do you understand? That's not the place to go have fun, okay? It's cotton candy. You shoot like a duck with a little old BB gun rifle. Buy your girlfriend a teddy bear, man. I'm gonna go ahead on you, Pryor. It's gonna be release your own reconnaissance on that hole that's gonna come in front of me. Now, what day can you come see me next week, Pryor?
We don't have a date for you.
No. What's your best day of the week, Pryor? You said you in school?
Yes, sir.
What day is there the least amount of schoolwork? Monday, Tuesday, Wednesday, Thursday, or Friday?
Wednesday morning, I can be there.
How about tomorrow? Is school closed tomorrow?
Yeah.
How about tomorrow, Judge?
All right, come see me tomorrow, Pryor. I'm gonna go ahead and release you on your own reconnaissance on this reefer case too. You understand? You understand?
Yes, sir.
And stay away from them church carnivals. Do you understand?
Yes, sir.
All right, do me a favor. I'm gonna release him on his own reconnaissance. Pryor, I want to see you tomorrow. You know where my courtroom is, don't you?
Yes, sir.
I'm gonna see you tomorrow at 9 o'clock. All right, sir?
Sir.
This is embarrassing, Pryor. You got my name on your head. All right, I'm going to see him tomorrow at 9 o'clock. He's RR on both counts.
Good luck. Thank
State
you,
that
Judge.
doesn't prevent you from following him out right. Whatever you
Bob
got to do.
Thomas.
Okay, yes,
All right,
sir.
where's Bob Thomas at? Bob, where are you?
Main jail?
Bob, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? All right. Bob Thomas, you got yourself capiouses for driving while license suspended, 250, and failure to register a car. I'm going to go ahead and note that you need to go ahead and pay that money. You understand that, Mr. Thomas? Pay your money and get on out of there. Thank you. Where's Emilio Rochester? Rochester.
He's president of the main jail, Judge.
Rochester, they got you for you
Jaywalking, Judge.
You don't tell me that you back at the All Saints Catholic Church, that carnival. I done been there before. I know exactly where it is. My secretary used to work one of the booths there. So you at the carnival, you walking across the street, the man sees you crossing the street. He tells you he don't want you to get struck because somebody else allegedly got struck near the area. So he's trying to stop you from getting hit, and then you stop allegedly cussing the man all out and stuff, and kept walking. So I do fine for refusing an officer resisting without violence. It's going to be $100. However, failure to obey the officer, but resisting without obstruction is $100. It's going to be failure to obey $100, and I'm going to ROR you on the crosswalk issue. Post your bond and get on out of there. Do you understand? Do you understand?
Yes, sir.
Thank you. Where is Erie?
Judge,
yeah, go ahead, sir.
I'm going to move for reconsideration.
Yes, sir. Hold on
Ask
a
the
second.
court
Let me
to
get my
consider
paperwork. Hold on.
ROR on all counts.
Miller, go ahead, sir. What's your reconsideration?
Well, Judge, he's got a job. He works at Tupelo Tires. He lives with his family. He helps take care of his two little sisters, and he's saving up money to go to Atlantic Tech. He wants to be an auto mechanic, Judge. Can we go ahead and ROR him on this charge?
Does he have a record, Mr. Pryor?
I'm checking right now, Your Honor. It appears that Mr. Rochester has some juvenile priors. And he has a petty theft, an adult petty theft that was committed in 2014. And all of his juvenile priors were petty thefts, with the exception of a battery acquittal, but it was acquitted. So all of the cases that are on record are petty thefts.
Emilio, can you hear me?
Yes, sir.
Life is simple. Cross the street where you're supposed to cross it at. I'm going to go ahead and release you on pre-trial release. You understand?
Yes, sir.
Just cross the street where you're supposed to cross it at, all right, sir?
All right.
Do you know how to plug a tire?
Yes, sir.
You ever worry about one of them tires blowing up in your face when you like putting air in it? Yes or no?
No, sir.
I read about a man in Colorado who was working for a tire company who was putting air in the tire and the tire exploded and killed him. Be careful, you understand?
Yes, sir.
It's going to be released on your own reconnaissance with the admonition to just cross the street where you're supposed to cross it. Where is Eric Fernandez Cruz?
And Judge, just for the record, he needs to report to pretrial before noon on Tuesday. Is that correct?
Yeah, you need to get the pretrial before noon on Tuesday. Pretrial, put him in your program, okay? You got to go to work. Yeah.
Thank you, Judge. Spanish? Judge, we'll need a Spanish interpreter for Mr. Fernandez Cruz.
1 second, Mr. Miller.
Yes,
Yeah,
sir.
put him on pretrial. This is stuff about failure. Man said cross over there, you got to cross over there, but that's the allegation. So he has to. So it's just going to be RR on all counts. Just get him over to pretrial. He needs to get back to work. Because if he's not working, ain't no money coming in. Ma'am, what is your name?
Good morning, Your Honor. Spanish interpreter present. Luz Angela Lopez.
I thought that was you. Do you swear to tell the truth, the whole truth, and nothing but the truth of God?
I will, Your Honor. Luz Angela
But to
Lopez.
use your special skills to assist this court?
Absolutely, Your Honor.
You translating from English to Spanish to English, best of your knowledge?
I will, Your Honor. Luz Angela Lopez, LPEZ, Spanish interpreter for the courthouse.
Thank you. Eric Ramon, raise your right hand, sir.
Señor Eric, levante su mano derecha.
Yeah, his name is Eric Ramon Fernandez Cruz.
Señor, señor, su nombre es Eric Ramón Fernández Cruz.
Hey. Put your hand
Yes.
down.
Baje
Thank
la
you.
mano.
Tell him I found probable cause that he was drunk.
El señor juez encuentra motivo fundado para detenerlo debido a que usted estaba embriagado.
And I'm going to go ahead and his bond is set at $500.
I'm sorry, Your Honor, 500.
500.
Le impongo una fianza de $500.
Tell him the cop says he was going too fast and he was watching TV.
El señor agente de la policía que lo detuvo escribe en su affidavit que usted estaba embriagado y que tenía el televisor prendido.
Tell him I'm going to go ahead and release him on his own facial recognition on those two counts. I'm only going to have him post bond at $500. Tell him.
I'm so sorry. Your Honor, may Your Honor repeat,
I'm going to slow
please?
it down. I'm so sorry. Tell him on the other counts of speeding and watching TV while driving, I'm just going to go ahead and release him outright on his own reconnaissance.
Señor, por las acusaciones de estar excediendo la velocidad y por la acusación de estar conduciendo mientras miraba televisión, lo deja en libertad bajo su propia responsabilidad.
Tell him he needs $500 to get out of jail on bond.
Necesita pagar una fianza de $500 para salir en libertad bajo fianza.
Thank you.
Gracias.
All righty.
Thank you, Judge. Do you want to do other Spanish, Judge, or?
Well, let me wait until I get to it. Michael Smith.
Yes, sir.
Michael Smith.
Page 11, Smith. Medical reset, Judge.
Oh, that was a medical.
It's a medical reset.
Medical reset.
Sir.
Medical reset. Where's Dwayne Spence at Spence?
Also a medical reset, Judge.
Jeffrey Kuntz.
He's present at the main jail.
Mr. Kuntz, how are you, sir?
I'm all right, sir.
I've got 2 probable calls on him. Did you see it prior?
Yes, Your Honor.
All right, Miller, you've got 2 probable calls. Did you see it, sir?
I read them both, Judge.
Okay, sir. I'm going to go ahead collectively. I'm going to find that there's a petty theft and bond is set at $100. However, the liquor bottle aggravated battery, I do find PC for it. We're hitting the man with a liquor bottle across the head. Its bond's going to be set on the aggravated battery. I'm going to set that for $5,000. You have no contact whatsoever with this individual by the name of Lucas Burkhardt and you're not to go back to that Target store. So you've got $100 bond on the petty theft and $5,000 with no contact whatsoever with the guy with the liquor bottle. Thank you very much. I'm done with this one.
Judge, would you move for reconsideration?
Yes, sir. Go ahead.
Judge, Mr. Kuntz has been living here in South Florida for about a year. His daughter lives in Miami. He just got a job. He's starting at CNC as a survey taker. No money in the bank or real estate. He is, however, a registered voter. He has no one to help bond him out. Furthermore, Judge, he's a veteran of the United States Air Force. He served from 1986 to 1990, was honorably discharged as an E4. So, based on those mitigating factors, Judge, I would ask the court to reconsider the bond on count 2.
You were in the Air Force. What bases were you at, Kuntz?
What bases? I was in Germany for 2 years, in Florida for a year, and in tech school for a year.
What area did you work in?
I worked on F-16s, Aircraft Armament System Specialist.
I was there in the military from 84 to 90. You said you were there from 86 to 90?
86 to 90.
I was there 84 to 1990. I was over in England. I used to go to Germany trying cases and stuff. Did you ever go to Cripple Creek? Bentwaters in England?
No. No.
Milton Hall, Lake What bases were you at in Germany?
What, Ramstein Air Force Base.
You said Ramstein?
Yes.
Yeah.
Yes, Judge American, because Veterans Court. I'm sure it's because Veterans.
The FE, you might be an FE.
Oh, he's an FE, but yeah.
Okay.
He's an FE with Judge American. Your Honor, Harold Brown Baptist State. I think based on the facts, I think the bond is appropriate under the circumstances. Rather violent. I mean, although he was involved in a mere petty theft, he kind of took it a step further when he hit someone in the head with a liquor bottle, an empty liquor bottle. And I think based on those facts, I think the bond that was set initially by this court is appropriate under the circumstances.
Judge, I'm not sure that those are related incidents.
No, they weren't.
I'm not so sure they are too.
I don't believe they are, Your Honor.
I'm going to reduce bond to $2,500. However, I'm going to put you on pretrial release. Do you understand, sir?
Yes. Yes, sir.
Pretrial release, I'm going to reduce it to $2,500. This case should go to Judge Merrigan. Mr. Pryor, I can't figure out why they was on a bus fighting with bottles, but it's not for me to figure out the word within or word without. It's just to make a decision on proper cause.
Correct, yeah.
Yeah, it's going to be pretrial release, but I also want to post a $2,500 bond. I'm going to reduce it in half. It's an aggravated battery. That's a real serious charge. What were you in the military? Were you a sergeant or what?
Yes, I was a sergeant in the Air Force.
Yeah, you were a sergeant. You shouldn't be here.
You're absolutely correct.
Yeah, it's going to be a RR on count 1, the petty theft out of Target.
Okay.
But on count number 2, the aggravated battery, that bottle, it concerns me. He's a veteran, but I need to go ahead and make $2,500 plus pretrial release.
Thank you, Judge.
Jeffrey, good luck, sir. Alejandro Maymont, where are you, sir?
Main jail, Judge.
Alejandro, how you doing, sir?
I'm doing good, sir.
Hey, I'm not too happy, man. I read it. It's been several times you've been arrested for driving while license suspended. Actually, 7 times. I'm done with it. I'm setting your bond at $2,500. You can't drink. You can't drive without a license, sir. $2,500. This is not a game. This is the 8th time. I'm done. $2,500. The bond is set.
Yeah.
Thank you. You got to get a license, sir. Thank you. I'm done.
Thank you, Judge.
All right, who's next? Where is James Curler?
Curler? 2,500, 250 to a bar.
Curler, where are you?
He's present at the main jail.
Sir, allegedly you took a box cutter and stabbed another man in the ear. Aggravated battery. It's set at $10,000. Okay? Do you know where this man is from, Mr. Miller?
I do not.
I need you to have no contact with Thomas Westmoreland. No contact with the man. Allegedly you stabbed him. Thank you. It's $10,000 bond. Who's next? Where's Jonathan Doe?
Good luck.
Right here, y'all.
Come on, Doe.
Come on.
Though I do find PC for breaking into a conveyance unoccupied and also possession of our proselyam. Now, the concern I've got is that bond is set at $5,000 on count one, and our proselyam's already got a bond set at $1,000. Post your bonds and get out of there. Where is Irvin French? French, I found possession of
President,
cocaine.
main judge, we're going to be asking the court to reconsider the bond on count 3.
Let me take a look at that. It says no bond.
No bond, no count.
My
3.
concern, Miller, is I'm looking at my notes. Why do I think that this is a Flocka issue?
Well, that's what the charge is, Judge.
I'm only asking.
Judge, it's my understanding that this case is from last year, he's telling me about 6 months ago. He tells me that he kept calling his bondsmen to find out when the case was going to be set for court, and he never got a date.
Okay, Mr. Miller, the reason I'm asking about the Flocka is, if you look at the initial capias, it was possession of PVP.
Right.
And the concern that they're having across the spectrum is just releasing people out with the Flocka issue, and they're out of it, and there's no place to go. But in this case, that's why I asked the question in my notes. So in 15-11866 CFA, it's a capias issue for Judge Usan involving so-called alleged Flocka, and he signed it on February 8th, 2016. Now, Mr. Pryor.
Yes, Your Honor.
Can I touch that no bond hold set by?
No, Your Honor, because it was set by.
It was set by Usan. I can't touch that, guys.
Right.
In fact, I can tell you I can't touch it as a case on point. So it is what it is. Now, however, the possession of cocaine is already set at 1,000, and you got 250 for resisting an officer without violence. So at this point in time, it is what it is. He needs to be taken back before Judge Usan.
And you're going to see Judge Usan on Wednesday. Good luck. Gene Johnson.
All right. Thank you. So where is my friend? Where's Gene Johnson? Gene, where are you?
Present.
Gene.
Present.
You got a $500 capias out of Monroe County, sir. That's down there in the Keys. So I'm going to go ahead. I'm going to set your bond. I find PC for resistance.
For the record, I would like to establish to the court that I am the beneficiary of that foreign trust that the state is trespassing on. As beneficiary, I'm going to appoint you trustee to give me all the IRS forms so I can discharge this debt. I'll ask the court to honor House Joint Resolution 192 and discharge if this is a public debt that the court is seeking.
He's a sovereign.
I don't know, Judge. He didn't sign this up. I don't think he wants us to sign him up.
I noticed that there's a flag with the gold fringes. That means this is the Article 1 Court of Equity. I hold the highest claim in this court. I have a perfected security that if necessary, I'm not disputing the charges. I want to settle this matter in 2 days under certain conditions. One condition that all debt be discharged. That would consist of IRS Form 56, where I will appoint you trustee so I can sign all the documents. Followed by Form 1099. Is there any living soul in this court that has a higher claim? If not, then
I don't know either, Judge.
This is a court of equity. Is there any objections to that? I believe the Attorney General handles titles. That would be Pam Bondi. From the time the defendant has been incarcerated, they supply no paper. If necessary, I will put on record an affidavit of fact stating that. In return, I would like it a wet seal notarized so I could put on public record.
Sir, I've heard and I have digested every single word you have said. And I don't have a clue as to what you're talking about.
To make it more clear, this is a war court. As a civilian, this is not the venue to even try this case.
Okay, sir. Thank you.
To my understanding, this is on the internet.
Okay, sir.
One more thing, I'm giving notice to the court that there is a contract in effect where for every 5 minutes I'm detained against my will. Am I free to go? Every 5 minutes I'm detained against my will. The state agencies, officials, all representatives of the United States, including the District of Columbia and the territories within, are to pay me, the principal, Gene Alfred Johnson in all caps, 10,000 U.S. silver dollars per every 5 minutes I'm detained
Yes,
against
sir.
my free
Yes,
will.
sir. Okay, court deputy, can you come here a second, sir? Deputy.
If necessary,
You're on deck.
if necessary, if this necessary, we'll have an in-camera hearing.
Come on.
Deputy, can you kind of sit him down while I make my ruling?
We're gonna take care of him.
I'm gonna go ahead. Count one's gonna be $250. Count
Do
two
you have that authority?
is driver
Do
license
you have the
suspended. It's gonna
authority
be
from Congress to
$750.
issue that?
I'm gonna release him on his own reconnaissance on the disobeying a light and fade away a safety belt. Out of cold hold is from Monroe County. He has a post of $500 bond. The court's entered its order.
One more time, Your Honor. Sorry.
You're 250 on count one. 750 is already sitting there on the driving license suspended. And Monroe County's already got a $500 capia. Sir, I've digested your arguments. Thank you, sir, for making them. Okay, where is Tyrone Johnson at? Tyrone, where are you, sir?
Judge, this is Mr. Johnson.
Mr. Johnson, sir, I do find precedent for grand theft auto. Your bond is set at $1,000. Possession of a controlled substance without a prescription is set at $1,000. Cannabis is $100, and $750 for driving with a license third or more scenario. And allegedly, it was a flocka was the so-called drug of question. So post your bond, sir, and good luck. Where is Mr. Calvin Damone?
Hey, Your Honor, good morning, sir.
Good morning, sir.
I've
I've got another so-called.
No, sir.
Another so-called Flocka PVP case. I do find it, sir. They've got you possession of Flocka with intent to sell or deliver. And also they've got you for a writ of arrest for $295 for child support. You got to purge amount, sir. I can't touch that, sir. You need to go ahead and pay the $295 for the purge amount. And also you need to go ahead and post bond for $1,000 for the so-called alleged possession of the so-called PVP. So good luck, sir.
Judge, Mr. Damon would like to address the court. I've advised him not to
You may,
discuss
sir.
the facts
Mr.
of the
Damon, don't
case.
discuss the case, sir. Do you swear to tell the truth, the whole truth, and nothing but the truth of God?
Yes, sir.
Damon, that $1,000. I'm worried about the Flocka, man. Go ahead. What do you want to say, sir?
Well, Your Honor, the guy was bringing me some Infamil milk. I didn't know that, he had whatever inside his car. So, I went to his car. So they didn't get anything off of me. So how can they trust me with that? I just had a 5-day-old baby. And the guy had nine cans of Infamil milk that, I went to his car, so the police just thrashed his car. So how can I be charged with that?
Okay, if you got a 5-day-old baby, Mr. Damon, you should be asking me to increase your bond so you can stay in there. It was a 5-day-old baby gonna be crying all night long. You sure you want that?
No, sir. But I was buying the nine cans of milk. You know what I mean? For my baby was born Tuesday at 2:14 p.m.
So
I was there.
You was there?
Yes.
Miller, does he have a baby? Do you know Mr. Miller?
I'm sorry, Judge?
Does he have a baby?
He says he does. He was under oath.
You can call my baby mom right now.
Mr. Power.
Yes, Your Honor.
Does he have a record? Because I'm concerned he's got 17 individual baggies of this so-called Flocka.
Right, and he was and it's alleged that he was in a stolen vehicle, Your Honor.
The vehicle was allegedly stolen?
Yes, Your Honor. Is this Calvin Damon?
I'm dealing with Calvin Damon.
Right. Yeah. But what I'm saying is the stop was effectuated due to the fact that he was a front passenger in a stolen vehicle.
I'm going to keep it at what it is, 1,000. I was going to try and give him a break to get on to see his baby, but...
That's the guy right there, who I was buying, the milk from. He told me to go get the milk, so, I'm grabbing the milk at the same time the police came.
I'm looking at his record now, Your
I was
Honor.
sitting in front of my house. finna buy 9 cans of milk for my baby. The man said, go grab the bag from out of his passenger seat. So when I went to go grab the bag, the police bum rushed his car because whatever car he had, his girlfriend reported a car stolen on him, not me. I'm
think
in
I'm
front of
gonna
my
go.
house at
Hey,
840 Northwest 12th Avenue.
listen to me,
man.
Damon, you need to get up and take care of that baby. That baby gonna cry not long. I'm telling you right now. I'm gonna go. I'm sorry. Go ahead, Miss.
Would you consider reducing the bond in light of these circumstances?
I would reduce the bond, but I want him on pretrial because I'm worried about the Flocka issue.
Correct.
I'm thinking he's got some mental issues with this Flocka stuff.
I don't deal with that, you know.
Yeah, you know, you may be right, but I'm just concerned.
Your
okay?
Honor, in all
Go
candor
ahead,
to the
man.
court, Your Honor,
I work every day, man. I work for R&R, man. World Famous Barbecue. That's what
Your
I
Honor,
work
all
for.
candor to the court, and as an officer of the court, I'm looking at his priors. Just in Broward County alone, it appears that all of his offenses are driving offenses. There is a robbery that's showing up, but the date of birth is a little different. I'm confirming that right now. But right now, I see no other drug offenses on his record, prior drug offenses, either as a user or a dealer. So in light of that, I wouldn't object to the bond being reduced. But the fact that he was in it, I mean, we can't get past the fact that he was in a stolen vehicle or allegedly in a stolen vehicle, and that amount of Flocka was actually found in the vehicle. He also has an extensive, and yes, Your Honor, he was found guilty in 1994 for robbery with a deadly weapon, armed kidnapping, and attempted robbery with the deadly weapon.
What year was that, the armed kidnapping?
Armed kidnapping, 1994, Your Honor. That was a long time-
1994,
long
that
time
would have
ago.
been how many years ago? 94, that's like 20 years
20
ago.
years ago, 21 years ago.
He was 14 years old,
22.
Judge.
Okay, Miller.
He's charging
He
adult.
mentioned something about working. Ask him, raise your hand, Damon. Do you swear to tell the truth, the whole truth, that nothing but the truth of God? Sir, where do you
sir.
work at?
I work at R&R World Famous Barbecue right on 31st and Broward.
Ain't no barbecue at no 31st and Broward.
Yes,
I
it
go to every
is,
barbecue
y'all.
place in town. What company you work for?
Yes, it is. It's right. It is. It's right on 31st and Broward, right there behind the liquor store.
Hold on a second. 31st and Broward.
That's where
That's why they call me Kentucky Fried Chicken.
Yes.
And then McDonald's. I grew up in that neighborhood. Right behind this, where I grew up on 3rd Street.
I work. It's in the back behind the club 54.
And you make barbecue there?
Yes, sir.
Because I found I go get barbecue every Friday night. Barbecue and sauce. You know how to make pork sauce?
I cook that, you know. I do.
You know how to make sauce?
Yes, sir.
So, he ain't got no drugs, no dope in him. He's
Yeah,
sitting...
only thing I see here, I actually looked at something here, but it's a Judge Robolo case in 2001. I don't know if Judge Robolo is in juvenile then. But, I mean, it was 1976, so he was old enough in 2001. It was a possession of cocaine. Purchase, sell, or deliver cocaine in 2002. He was actually adjudicated guilty for that. He was arrested recently, Your Honor.
Hey, Damone, I tell you what, you still got to... You got to sell a whole bunch of ribs. You got to pay that girl some child support of $295. You got a whole bunch of ribs you
Yes,
got to
sir.
sell. You understand, don't you?
Yes, sir.
I can't help you out with that. All righty? But I'm going to go ahead. I'm going to reduce your bond from $1,000. I'm going to put you on pretrial and make you post bond on $100, okay?
All right, thank you.
So post bond of $100, and you go out on pretrial, but you got to deal with that girl with that $295 child support. I can't touch that. You understand?
All right, sir.
Are you releasing him to pretrial release also on the writ?
That's what I do.
I can't touch the writ. You got to go back before Judge Early.
The writ's a civil matter.
So I can't touch the writ. Them dependency judges go, they go kind of, not dependency, but the family law judges on those writs, because they've already determined that he has the ability to pay and, and so forth.
Okay, I need his address, Your Honor.
Yeah, so he needs to just go, he needs to be brought before his family law judge to see if they'll deal with the writ, the purge amount, because they've already had a hearing on that. So I don't want to step in and say, yeah, he needs to sell us a lot of barbecue, because I get that man $35 every Friday. You got to get up to $295. Go ahead.
I need his address, Your Honor.
Yeah, give us your address. Damon, give us your address, sir.
Your address.
Give us an address.
It's 840 Northwest 12th Avenue, apartment 2.
zip code?
33311.
Any more information you need, Clerk? All right. Anything else, Peter, you need? Okay, thank you, Damone. Good luck, sir. And take care of yourself.
All right, thank you.
All right. I'm going to check him.
This is ready for you.
All right, where's Rakeem Baptiste?
This is Mr. Baptiste, Judge.
Hey, Baptiste, Destra's looking for you. You're on probation for a pawn shop issue. He's got a no bond holdout for you. So Judge Destra's looking for you, man. I can't help you out. You got to go see your judge. Good luck, sir. Where's Andre Ward at? Ward, where are you? Ward, I do find PC for disorderly conduct. It's $100. Trespassing is $100. Threatening to harm cops, serving a family is $3,500 already set. Loading and prowling $25. Possession of a blank, fictitious, unlawful driver license $1,000. Resisting is $100. And use of a false identity affecting your so-called alleged cousin is another $1,000. Clerk, I'm going to go ahead. Bonds are set. Nothing I can do for you. Good luck, sir. Where's Jonathan Rounds at?
Main jail, Judge.
I'll stand down, clerk, until you
Judge.
caught up.
Mr. Ward was hoping to address the court to see if you would reconsider and lower his bond. Go ahead.
Who is that right there?
Good morning.
Are you Rounds?
Good morning.
Yes, Andre Ward. Andre Ward.
Oh, let's go back to Andre Ward. Mr. Miller, what's Ward asking me to do?
He's asking you to reconsider his bond, Judge. I did not get a chance to interview him. I'm going to let him provide his mitigating factors to the court. Go ahead.
Okay, Your Honor, I was arrested within a block of my house and a block of my job. An officer approached me that I was having a bad day. I told him in order to get respect, he got to give it, and he put the pen on me. Power of the pen. None of these charges are true. All I want is a reasonable bond to get out and fight this case.
Judge, I would argue, just by way of mitigation, the threat alleged to get him is kind of vague and might not even rise to the level of an assault.
I've been living in my neighborhood for 40 years, John.
Mr. Miller, he said allegedly to the officer, take the handcuffs off me. If you don't, quote, when I get out, I'm going to get your fuck ass and break your jaw. I'm going to bury your fuck ass five squares. That's not vague at all. That's clear, that's concise, that's specific, and I do apologize for my language, but we need for the appeals court to their record. But again, Mr. Miller, that's not unclear, that's not vague, that's not confusing. It's a clear-cut threat to an officer. It is what it is. Bonds remain the same. It remains the same. Thank you. Where is Mr. Jonathan Rounds? Jonathan, where are you?
Mr. Rounds, front and center.
Mr. Rounds, I've got $10,000 bond. I do find PC for robbery, no firearm or weapon, and resisting without violence is $500. Allegedly, you're inside of the establishment. It's Sears. The loss prevention officer approached you. You were struck twice in the face with a closed fist and so forth. Alrighty, I'm done. This is a $10,000 bond, a robbery. No weapon or firearm. Striking the man in the face twice with a closed fist. Again, you're not to return to that Sears town. Do you understand, sir? You need to post your bond. It's a robbery using force. Thank you.
Thank you, Judge.
Where's Brandon Amato? Let's go, Brandon. It's a burglary of a dwelling unoccupied. Now, this was an interesting case, very strange.
Yeah.
You kept coming back allegedly. So I'm going to go ahead. It's $5,000 bond. I don't understand the so-called dynamics of the case, but it is what it is. So again, bond is set at $5,000. All right, you need to post bond. Do not return to that property. And you have no contact with Veronica Shavira or Daniel Xavier. I do find PC for burglary of an occupied dwelling. Strange set of facts, but it is what it is. Where's Angel Rodriguez? Angel, come on, sir.
Please. Judge, we need a Spanish interpreter. I asked the court
to... Spanish interpreter. She's still here. Ma'am, thank you so much. Are you Creole? We may need you. Hold on now. I don't know yet. Interpreter, do you once again come here to use your special skills to assist this court and to assist these people?
I will, Your Honor.
All right, thank you. What is your name?
Luz Angela Lopez, Your Honor.
Thank you. Tell Angel Rodriguez to raise his right hand.
Señor Rodríguez, levante su mano derecha.
Senor Rodriguez, do you swear to tell the truth, the whole truth, and nothing but the truth, except your God?
Señor Rodríguez, ¿usted jura decir la verdad, toda la verdad y nada más que la verdad ante Dios?
Sí.
Yes.
Tell Senor Rodriguez that he has a no bond hold for a felony capias.
Señor, usted tiene no puede pagar una fianza por. I am so sorry, Your Honor. The interpreter just went blank. May Your Honor
It's
repeat,
a no
please.
bond hold.
Yes, Your Honor.
For a felony.
Yes, Your Honor.
Possession of heroin case.
Señor, debido a un caso de heroína, usted no puede pagar una fianza para salir en libertad.
Tell him he also has a capias arrest warrant, and I've got bond set at $500.
El señor juez impone una fianza de $500 por una acusación por una orden de captura que tiene en contra suya.
Tell him that case is for prowling.
Y ese caso es de una acusación que tienen de estar merodeando.
Tell him I can't do much for him. Good luck.
El señor juez dice que no puede hacer mucho por usted. Qué buena suerte.
Thank you.
Gracias.
Where's Ephraim Flowers?
Judge, he's present at the main jail.
Alrighty. Ephraim, man, you got yourself a no bond hold. It's an out of county felony. Mr. Pryor, who's looking for him?
Your Honor, Palm Beach is looking for him, Your Honor.
Palm Beach County is looking for you, sir. I can't do much for you. It's a no bond hold on that. On my count, petty theft, sir, it's PC. I'm gonna just set it for $25. Now, and that's coming straight out of Macy's. You got 2 misdemeanor capias for $500 a piece. You got to go take care of that.
Robert
cannabis
was supposed to
capias.
handle. Oh, I'm sorry, sir. Robert Trapton was supposed to handle him. We went through this. This is like 2014. I was just fighting the case while with my license. I wanted to keep my license because it was a weed charge, but I want to get rid of it.
Okay.
So I can just go handle the Palm Beach thing.
All right, again, I'm going to go ahead. Your capias is already set at $500 a piece. $500 a piece. Can he be brought back before those capias as judges, clerks, so he can resolve those cases? The man wants to get on back to Palm Beach, and I can understand that. I'm sorry?
Judge, he's got a court date for Wednesday.
Okay, he's set for, I think it's the 17th, Mr. Miller. Tell him he's going back before the judge to resolve these cases on the 17th. Today is the 14th, so I guess that's going to be Wednesday. So on next Wednesday, you got a chance to resolve these in front of the judge, okay? Good luck,
Right,
Flowers.
sir.
Where's
All right.
Henry Ducamel?
He's a medical reset. Rodrigo?
Medical reset on Ducamel. Where is Rodriguez Peltron?
He is here, Judge. We need a Spanish interpreter, please.
Interpreter, this is my day.
Yes, Your Honor.
Do you swear once again to use your special skills to interpret from Spanish to English and English to Spanish?
Yes, Your Honor. Luce Angela Lopez.
Tell Senor Peltron I said Happy Valentine's Day and good morning.
Señor Peltrán Rodrigo, el señor juez le desea feliz día del amor y la amistad y buenos días.
Senor Peltron, apparently they said that you were sitting on a dairy case at a place called Dean Foods.
El señor juez está leyendo el affidavit y dice que aparentemente usted estaba sentado sobre una caja de lácteos en una tienda que se llama Denny's Food.
Tell him a police officer allegedly walked up to him and asked him a question. Do you have anything on you that I should know about?
Supuestamente un agente de la policía vino y se acercó a usted y le hizo una pregunta que si usted tenía algo en su persona que él debería saberlo.
Tell him, as a result of events, he and now has a cocaine case, and I do find probable cause for possession of cocaine.
Debido a los eventos que sucedieron en ese momento, ahora usted tiene un caso, una acusación de posesión de cocaína y el señor juez encuentra motivo fundado para detenerlo por esa acusación.
Possession of marijuana.
También tiene una acusación de posesión de marihuana,
Having a pipe.
de tener una pipa
And illegal possession of a shopping cart.
y también lo acusan de posesión ilícita de una canasta de compras.
Tell him his bond is set at 1,000 for the cocaine.
La fianza que le impone el señor juez es de $1,000 para la posesión de cocaína,
100 for the cannabis,
$100 para la posesión de cannabis,
100 for the pipe,
$100 por la pipa
and $100 for that shopping cart.
y $100 por esa canasta de compras.
Miller, is those shopping carts still a third-degree felony?
Judge, I was just looking up the statute. It's not in my statute book, but I would argue that a dairy case is not a shopping cart.
It's being charged with first-degree misdemeanor, I think.
Señor Beltrán, el señor juez le está preguntando al señor abogado allá presente si el caso de posesión ilícita de una canasta es un delito grave de tercer grado, y dice el señor abogado defensor allá presente que según los estatutos
And Judge,
no.
further,
Yeah, go ahead, Mr. Miller.
I would argue that there's nothing, and I may have missed this as well, but there's nothing in here that says that there was cannabis present.
También el señor abogado allá presente está argumentando al señor juez que
So I would
según lo
ask
que
the
se
court to find no PC on counts
dice aquí en el
1
affidavit,
and 4.
no hay en ningún momento que se diga que había algo que tuviera que ver con el cannabis, y por eso le pide al señor juez o argumenta que no hay motivo fundado, que no encuentre motivo fundado.
Your Honor, the state will concede that point.
El señor abogado fiscal concede en esto.
He changed the charge, he being the officer.
El agente de la policía supuestamente cambió la acusación.
Looks like on a booking report, and even on the PC, it has marijuana, but then when you look at the substance of his report, there's no mention of the cannabis.
Tell you what I'll do. It's just going to be you ready for this part? Count one, stick with this.
El señor juez va a dictarle a la señora secretaria.
You know, no PC on the cannabis.
No encuentro motivo fundado en cuanto al cannabis.
1,000. RR him on the drug paraphernalia.
Lo dejan en libertad bajo su propia responsabilidad en el uso de adminículos.
Possession of a, because it falls in the shopping cart or laundry cart, but make it RR on this dairy case.
Dice que lo deja en libertad bajo su propia responsabilidad en cuanto a la caja de lácteos.
Yeah, he only got to post 1,000 on the cocaine.
$1,000 de fianza es lo que tiene que pagar por la posesión de cocaína.
PC, I'm finding PC on everything except no PC on cannabis.
Encuentro motivo fundado.
PC, but I'm going to release him on his own reconnaissance.
Encuentro motivo fundado en todas las acusaciones excepto por la acusación de cannabis, pero que lo deje en libertad bajo su propia responsabilidad para los otros. $1,000 para la cocaína. Y encuentro motivo fundado. Para la canasta encuentro motivo fundado. Encuentro motivo fundado para estar en posesión ilícita de la canasta de compras, y le imponen $100 de fianza.
Tell him good luck.
Buena suerte, señor.
Good luck, Mr. Felton.
Where's Bernard Green at? Green.
He's coming right now.
He's coming, Judge.
Green. Go. Come on, man. Judge, wait. Mill, is he with you, Green?
They're going to get him, Judge. He's in the holding cell.
Okay, where's Michael Hernandez? We can do him first. Hernandez.
He's in North Broward.
Let's go to Michael Hernandez on North Broward. Hernandez, can you hear me?
Yes, sir.
I found PC for you for possession of alprazolam, possession of cocaine, paraphernalia of $100, possession, and a municipal violation of $25. At this point, you need to go ahead and post your bond, sir. Do you understand?
Yes, sir.
Your Honor, may I be heard?
Yeah, go ahead, ma'am.
Your Honor, would you be inclined to ROR him on the municipal ordinance? He has bonds on the other cases. In addition, would you be inclined to reduce his bond on any of the other offenses? This is his first charge. I'm not sure if Mr. Fire was able to look that up. He lives in Broward County. He has family here, and he also has medical issues that require specialized treatment.
Hernandez, are you a working
Yes,
man?
sir.
Do you work, sir?
I'm on disability, Your Honor.
You're on disability.
Yes, sir.
Your Honor,
Power, here's the deal. I already set bonds at 1,000 on count one. I probably am 1,000 on count two clerk. And I win $100. I'll RR him on that little municipal ordinance. It's going to be an RR. Power, what's your thoughts about reducing the bond on this prazolam cocaine? The concern is the true, Ms. Batchelor. I can't think of any disability where cocaine helps it out. I hear you. It's just going to make anything worse.
Your Honor, he has an extensive, he has a juvenile record, I believe, but actually those are dropped. I apologize for misstating that to the court. Your Honor, I'm looking at his record. He has nothing but infractions. So, in light of the drugs that were found on him, I would object to the court reducing his bond, just based on the fact that he's found with prazolam and cocaine.
I will go ahead and note that it's going to be, I'm going to remain standing where I am. It's going to be 1,000 on count 1, 1,000 on count 2, 100 on count 3, and RR. Thank you. Good luck. Where's Manuel Lopez?
We have Mr. Green, Judge.
Okay, y'all go back to Bernard Green. I'm sorry. Bernard.
How you doing, Judge?
Hey, man, I'm doing pretty good. Happy Valentine's Day. How you doing?
How you better? I ain't doing too good.
All right, Green, here's the concern. I got you for possession and with intent to sell, deliver some cocaine in. I got bond set at $2,500 on there, and I got resisting without a violence at 100. So that's my decision. Do you wish to add something, Mr. Miller?
Judge, I did not get a chance to interview Mr. Green.
Yeah, I'm concerned because Green allegedly told a cop that he doesn't use the dope, he's only selling it. And that concerns the court, I think, sometimes more than using it. And
well, that's a lie, sir.
Yeah, he's telling the crowd that y'all hanging out with the biggest drug dealer in Hollywood, man. I don't know if he's bragging to the other people at the scene or what. So I don't know, but it is what it is.
That's stupidity, Judge. Why would I do that?
Yeah.
I'm highly intelligent. I graduated from school.
What school did you graduate from?
I graduated from MacArthur High School.
You don't have to wait.
So you're a Mustang?
No, that's MacArthur.
Yeah, MacArthur.
I went to MacArthur.
What he said?
I said I'm a MacArthur Mustang.
That's right. I just got through saying if you went to MacArthur, you're a Mustang.
Oh, yes, sir.
What year did you graduate? That's what I was saying.
I graduated 08.
You a spring chicken. I graduated from South Plantation in 1976. You just graduated in 2008?
Yes, sir.
Are you working? What are you doing with your life?
I work for Gallo Construction Company.
Working for a construction company?
Yes, sir.
All righty. I got your bond set at $2,500, Bernard.
Okay.
I'm gonna knock it down to $1,500. Okay, make it down. I'm gonna make it $1,000. I'm gonna knock off $1,500. I'm gonna make it $1,000. We're gonna put you on pretrial. Okay?
Yes, sir.
He's out on bond.
Yes, Your Honor.
Okay.
Your Honor, so the state would object to the bond being reduced, Your Honor.
Breen, you out on bond now. I gotta keep it at the same, so it's gonna be $2,500. Okay, sir?
All
Good
right.
luck. Yeah, I gotta keep it the same, bro. Good luck. $2,500. All right, sir. And $100 on count two. Thank you.
All right.
Manuel Lopez.
Good
Thank
luck.
you, Mr. Pryor.
Thank you.
Lopez. Yeah, it should go count $100. Lopez.
How are you, Your Honor?
Hey, man, I got you down here for $15,000 bond. I found PC for aggravated assault with a knife, man. Allegedly, the cop alleges that you unsheathed the knife and threatened him with it. So, you know what I mean? It is what it is, man. So I do find PC. I'm giving you $15,000 bond, aggravated assault on a cop, man. It is what it is. No harmful contact with
It's
the
on a
police
victim.
officer. I'm sorry, go ahead, Mr. Pryor.
Your Honor, I believe it was on a victim. I don't believe it was on a law
Let's
enforcement.
take a look at that.
Yeah.
Let's go back to that, guys.
Your Honor, the PC alleges that the victim by the name of Garfar was involved in a conversation with some young adults.
Because it wasn't charged as a police officer, so it is just a regular victim.
Yes, Your Honor, it's just a regular victim.
So when he said he didn't produce and unsheathed a 5-inch knife and threatened Garfar, fearing for safety well-being, then drew his weapon, and Lopez dropped the knife.
Yes, Your Honor.
All right, that's what threw me off. All right. So at this point in time, what's your argument regarding bond?
Your Honor, the state, in light
Miller.
of that, yeah, go
Excuse
ahead.
me, Pryor.
Yeah,
Miller.
yes, Your Honor.
Miller, have you had a chance to talk to him?
Judge, I did not. I was in the
Miller,
middle
let me
of
take
doing
about a few minutes so you can talk to him.
Yeah.
Thank you very much.
I'm in no rush. This is a serious thing. That knife charge.
Yes, sir.
That could put a man away.
Yeah.
Right now, it's only 11:35. We behind schedule, but Burger King got that special deal until around 6 tonight, so I'm okay. Go to recess for a few minutes.
Is Jones still in that precinct? Jonathan Jones?
Judge, I do have some mitigating factors I would like to
Okay,
provide
let
to
me
the
sit
court.
back in the chair. Okay, we're back on the record, folks, so we all can, let's go back to Mr. Manuel Alonzo Lopez. Give me,
Yes,
Mr.
sir.
Miller, what you can share with me, sir. You've had an opportunity. What do you want to say, sir? Go ahead.
Judge, Mr. Lopez has been living in South Florida for about 6 years. All of his family lives here as well. He is a chef at a restaurant called Zucuro. He works 6 days a week. He is saving up money to start Broward College in August, where he will be studying business. He has no money to bond himself out. He is a registered voter. His family's going to bond him out, Judge, and from what I understand, this is his first arrest. I would ask the court to take that into consideration and lower the bond. We would ask for $1,000.
Your Honor, I can confirm that I did a records check earlier this morning, and my initial check of the Florida system, he has no priors. But based on the facts of the case, Your Honor,
He has no priors?
no, Your Honor, no priors, but the state would recommend a $5,000 bond.
All right. Miller, here's my concern. Miller, I've eaten at every restaurant in this county. What restaurant does he say work at? Sephora? What did you just say?
Zucuro. It's by Rock Bar on Las Olas. It's a high-end restaurant.
Okay, now you don't got all hoity-toity on me. High-end, huh? Okay, so you say it's on Las Olas or someplace?
It's next to Rock Bar. It's like by the beach. It's like on the beach, literally.
Oh, it's a date, right?
And spell it for me, because you done been there. Everybody been to that. I'm going to Burger King, and y'all go to some hoity-toity place called Zucuro. Spell it for me.
I don't know how to spell it. It's Zucuro. It's a Japanese. It starts with a T. I wouldn't know how to spell it.
Okay, so you actually, do you cook food there? Are you?
Yes. I cook and I prepare food. I prep and I cook.
All right, here's my concern, Miller. Miller, I don't want to pre-try the case, but here's the concern. Allegedly, the so-called victim is involved with some adults regarding a vehicle that they driving in the area reckless and almost lost control. They say Lopez wasn't even involved in the whole incident. He come out the house with a knife. That's the allegation of what I'm reading. Is that how you read it, Mr. Pryor?
Yes, Your Honor.
That is not what happened.
Okay, that's enough.
Son, you're an adult. Sir, you said you want to, after you want to go to school to be what now?
I want to study business.
You seem to have a brain on your shoulders. Initially, when I thought it was 15,000 prior, I thought he was messing around. I misread 2 PCs this morning, so I thought he was messing around with a cop the way it was written. But allegedly, it was, I'm not saying a cop's any less than a regular citizen, or a citizen's any less than a cop. I'm not making that argument. But I'm going to reduce this bond. What can you pay? He has a clean record prior?
Yes, Your Honor. He only has traffic infractions in Broward County alone, and the state of Florida. From my initial check of the Florida system, there could be more throughout the country, but that's my representation to the court right now.
Pre-trial, what's the highest level of, is it level 2 or level 100? What is the highest level?
Level 1 total lockdown, Your Honor.
What is it?
Level 1 total lockdown. That's our highest level of supervision.
It's level 1.
It's level 1.
I'm going to put him on level 1, but I'm going to also set your bond at $3,000. Do you understand?
Yes, Your Honor.
He can't go to work.
He can't work?
Your Honor, you
Level
could put
2,
him
he's
on a
allowed
level
to
2
work, but he has to
GPS
give them
monitor.
a schedule.
I'm going to give you level 2 GPS, but your bond is not going to be $15,000. It's going to be $3,000. You understand? I don't know why you got yourself involved in this, but whatever it is, you need to get out of it. Do you understand? You got a future. Do you understand?
Yes, sir.
Is that open schedule, Your Honor, with GPS monitor?
Yeah, these GPS monitor. You need to get over there and get some work so I can check this restaurant out. They make Japanese food?
I'm sorry?
What kind of food is it? Japanese?
It's Japanese. It's anywhere from like filet mignons to octopus salad, that type of stuff.
Is that you say filet mignon? You don't already hit me. I might even take my wife to a steakhouse now. And I heard that word filet mignon.
Oh, Your Honor, can we order no contact with the victim?
Yeah, what do you make? I'm curious. What do you make?
What
like
food
an
do you
hour?
make? What food do you make?
Oh, anything. Oh, lobster mac and cheese, any type of steak, any type of fish.
Lobster mac and cheese sounds good.
He got some brains. This guy right here, I don't know how he got himself. Okay.
Oh, Your Honor, can we order no contact with the victim as
Yeah,
well?
no contact with the victim, okay? So don't go back out there, you and your friends messing with this guy, you understand?
Yes, sir.
Yeah, don't go
Yes,
anywhere
sir.
near the guy, man, because the guy's got some issues, and he's got a gun, okay? All right?
Yes, sir.
So good
Thank you,
luck.
Judge.
I'm sorry, go ahead, clerk.
All right.
Yes, your pre-trial. His bond's going to be, I'm sorry, his bond's going to be $3,000. Pre-trial, I need to go ahead and have him post $3,000. He has some skin in the game. That'll make sure he returns. Where's Jose Santos?
North Broward, Judge.
No problem, Your Honor. He's going to get a medical reset, please.
Maybe pre-trial.
Medical reset, Your Honor.
Medical reset? Thank you. Where's Jonathan Jones?
Mr. Jones is
Jones, is that you?
All right. Yes, Your Honor.
You got a DUI fine, PC, $500. Resisting an officer with violence is $250. You also have, I'm just going to RR you on the other counts. All right, sir, they said you was mixing wine with vodka. You mixed wine with vodka, sir. I never heard of that before. Your bond is $500 on the DUI and $250 on the resisting with violence. Post your bonds and get out of there. RR on every other count. Thank you.
Judge, would the court consider pretrial for Mr. Jones? He is
State,
a
what's your
22-year resident. He's a 22-year resident of South Florida with strong family ties, including his mother, his father, and his grandmother. He works at Publix. He's been there for over a year.
Where does he work at?
He works at Publix, Judge.
Which Publix?
For over a year. Which one?
One on Westlake. It's between US 1 and 441.
Westlake.
What do you do for
They
Publix?
call it Westlake Homes.
What do you do for Publix? What do you
I work
do
in
for
the
'em?
produce department.
What department?
The produce department.
Produce, Judge. He also, are you attending now, or are you saving up to go to school?
No, I go to. I
He
go.
attends school at Sheridan Tech. He's studying HVAC there. He has some money in the bank. He is a registered voter. He served in the United States Navy from 2004 to 2012, and he was honorably discharged as an E5. I've been recruiting him to join the reserves.
So you're a Navy man, huh?
Yes, Your Honor.
Who's the toughest, a Navy man or an Air Force man? Who's tougher, a Navy man or an Air Force man?
Air Force.
That's what I thought you was gonna say. At this point in time, the DUI will stay at $500, but I'm gonna release you on your own reconnaissance on everything else. That'll
Judge.
save you $250. Good luck, sir.
How much do I have to pay?
Just the $500 for the DUI.
Where's Terrence McClendon?
Good luck.
McClendon, where are you? McClendon, good to see you, sir. McClendon, you got a no bond hold. The Department of Corrections is looking for you for a so-called parole violation, I believe. It's a no bond hold, so I can't touch you. I'm gonna go ahead.
Violation.
Go ahead, sir.
I'm not on parole. I was on probation. I was on probation. And then
Probation
but they
violation.
stopped.
Here's my concern.
Sold case.
Bachelor.
Yes.
He is on probation with who?
Say, you have where he's on probation, this 95 case?
Yes, it's an older case.
Okay.
I believe it's a Broward County case.
Since 1995?
Yeah, I'm checking right now. Double checking the case.
1994.
Okay.
Okay, so it's with the Department of Corrections, but it's a local probation officer. It's Singal.
Mhm.
That's what I couldn't find out. I couldn't find any paperwork, so I presumed it wasn't a local judge. Okay, so it's just Singal's got you. Okay, you got a probation violation with Singal. It's a no bond hold. At this point in time, on the unlawful possession of a personal ID of another, I've got you with 4 different people's ID, not one person. Your bond on that's going to be $4,000. And I'm going to go ahead. Your petty theft was 100.
You're increasing the bonds, Your Honor?
Yeah, I'm increasing that one on that one. He's got 4 victims, not one.
Yeah.
The way they got a
Can I
charge
say
is as
something?
of another. He's actually got 4 people's. Okay, he wants to talk instead of me. But Clinton, you go ahead and talk, and I'll just listen to you, sir. Because I can't even weigh my decision because you're talking. Go ahead, sir.
Young detective came and seen me about the issue about the cop.
Mr. McClendon, do not talk about the
They don't
facts
want
of
you
your
to talk
case.
about the case, sir. I
Do
know
not
you-
talk about the facts
So
of your
you
case.
can't talk about the case, okay? So don't interrupt me. Grand theft auto bond is already set at 1,000. I'm going to maintain that. Petty theft is 100. I'm increasing the bond. It's not one ID person. It's 4 different people's credit cards, allegedly. It's a $4,000 bond. Singal has a no bond hold on you, sir. You're not going anywhere till you go see Judge Singal. He can modify all my bonds if he wants to, sir. Now, I would suggest you not say anything, okay? Because you're going to go see Judge Singal real soon, sir, huh?
It's about the probable cause why I'm locked up for nothing. I ain't still no cop. I ain't got nothing to do with none of this here, sir. I ain't still no cop.
Let me move along.
And everything got something to do with what's in the car. Everything got something to do with what's in the car, and they ain't still no car. The police know. They told me they know who stole the car. They know everything, and they telling me that.
Yeah, I
you
need
know,
to go ahead and
that
kind of
we
move
just got
on.
in
I'm
possession
just
of
keep.
the car.
No, I'm sorry, Bachelor. I actually listen to people when they talk. So when he's talking, I'm actually looking at the PC again because I just don't like, brush aside because I used to be a defense attorney once. So but my concern is that, again, sir, I'm not going to argue with you. Let me just lay a record. He says he didn't steal a car. I'm not here to weigh that. That's not my concern. The problem is that the car was reported as being stolen, and allegedly he told the police officer that all the contents in the vehicle are his property and his sole responsibility. Again, I don't know what the relationship is, but I need to just move on. I'm going to go ahead and order a mental health evaluation. I think that's appropriate. I'm going to order a mental health evaluation, and I looked at the PC again. I'm going to keep it at $1,000 for the grand theft. Don't know if that was a miscommunication with the so-called owner of the vehicle and yourself as to how you got it, but when you have a stolen vehicle and you're saying it's yours
But the
and someone else
detectives
is saying
know I
it's
didn't
theirs.
steal the car.
I'm sorry, sir.
Detectives say he don't
All right,
know
sir.
I didn't steal the car.
Okay, thank you.
He got
Just
the
wait
whole
till I make my
report.
decision. All right, let's go. Mr. Michael Meltz, I need to get a mental health evaluation on him.
And Your Honor, just for record, I think his clarification was that he rented the car from an individual.
Yeah.
He wasn't aware of the items that were in the trunk of the vehicle. That's, I believe, his argument. Understandably.
Yeah, but it was reported stolen, no, Bachelor. I don't know, Bachelor, I'm just saying.
Yeah, I understand, Your Honor. What date is he in front of some golf?
Yeah, I need to get him in front of Singal.
But what is it?
There's no date.
Oh, okay.
Let's
How do
get
we
it
get
next
it?
week in front of Judge Singal.
Okay, thank you, Your Honor.
Yeah, 'cause
Yeah, there's no date on that.
Yeah. Okay, where is Michael Meltzer? Michael, where are you? Are you Michael?
No, Judge, this is Mr. Funches.
I'm
He's the
looking
last
for
one
Michael
on the
Meltzer. He's got some, is he here, Michael Meltzer there?
We're looking, Judge.
He was on loan.
2020.
But I'm not sure if he's still on.
Is he there?
Medical loan. No, Meltzer's a medical reset.
Okay, he's a medical reset. Thank you, Mr. Miller. He's a medical reset.
Yes, sir.
Where is Michael Bourne at?
North Broward?
Where's he at?
North Broward.
Thank you. Michael, how are you?
I could be better, sir.
I've got you, Michael, for a possession of heroin. And I'm going to set bond at 1,000. There might be some alleged suicidal issues there, so I need to go ahead and get him on some kind of psych eval.
There wasn't. There was just a miscommunication. They
Okay,
asked
do me a favor. Don't talk about the case, Michael. I'm sorry for right now, but
okay.
I'm just going to set bond at 1,000. I've got yourself on some alleged heroin issues. BSO, are you next to him?
Put him on
Yes, sir.
suicide
Is he on suicide watch?
Yeah.
Yes, he is.
Okay, good.
Okay, thank you. That's all I'm concerned with. I'm going to go ahead, post his bond at 1,000. Good luck, sir. Thank you.
Your Honor, one thing. I'm in drug court right now. I've been clean for 9 months. This is my first relapse, and I made a mistake and I overdosed.
Who's his judge? Who's his judge?
My judge is
Mr. Pryor can check. I believe he's in drug court.
Tobin Sr.
currently, So this case is the second drug court case that may be going in front of him.
Okay. Let me get you in front of Judge. Can you get him in front of the judge this week?
Judge, he's already been scheduled to see his drug court judge on the 16th, so he'll be.
Hey, Michael, do me a favor.
Judge
Tell the judge she's a friend of mine. Tell her she can go ahead and reduce my bond and make it nothing, okay? But I know she's going to be concerned if you've had your first relapse, and she may want to go ahead. She can reduce my bond to nothing, okay? Just tell her she can just go ahead and make it zero. But again, I'm just concerned because I had you down as maybe a possible overdose, okay?
Like I said, I've been doing very good.
Thank you.
In the system, but it's my first relapse.
Don't talk about the facts of your
good luck.
case.
I'm trying to stop smoking these cigars, so I understand. Good luck, sir, okay? Take care of yourself. All right, where's Harry Brooks at?
Judge, Mr. Brooks at North Broward, we're requesting a mental health
Brooks,
screen
how
for
you
him.
doing?
He is a hospital return.
Am I right, sir?
Yeah, they're requesting a mental health. Mr. Brooks, I've got about a half a dozen no bond holds on you on different counts coming out of Judge Mark Spizer's courtroom. So Judge Spizer actually is scheduled to see you, I believe, tomorrow. He's bringing you down to show. Yeah.
I completed my program. I came from it Friday to teach the Treasure Coast Serenity Center.
Okay.
I came back Friday.
He's got no bond on all of his counts, except the last two is misdemeanor capers counts of 1,000. Do you see it, clerk? Who asked for a mental health evaluation on him? Okay, you're gonna go see Spicer tomorrow, okay?
Yes, sir.
Any evaluations and so forth, he'll take care of you, okay, sir?
Yes, sir.
All right, good luck, sir. Happy Valentine's Day. Good luck.
All right,
I'm not sure of all the language, but I believe after he leaves that program, he's supposed to be brought back to court.
Okay. Okay. All right. Good luck, sir. You're okay. Thank you. Okay, the spouse is gonna say it. Okay, who's Tim Aaron Funches?
He's the gentleman standing next to me, Judge.
Okay, let me go back. We're back at the main jail. Mr. Tim Aaron Funches, I've got you for a $20,000 bond. Looks like it's in front of Judge McCarthy. And I'm looking at some of the documents, and that's going to be on count number 6 in 16750 CF 10A. So again, I believe you've got some other counts, and you have a whole bunch of multiple counts. But again, I'm looking at Judge Zeller's signed magistrate order finding PC. I'm struggling with it. It says no PC on count 6. I've got count 6 back in front of me. Is this for PC, Mr. Pryor? What is going on?
Yes. This was a reset because the state wanted time to perfect the judge didn't think it was correct. I think they just reset it for today because I don't believe that there was enough to go on. And I'm looking for the warrant as well.
I'm looking for the warrant as well, Your Honor.
I have it, Your Honor. In my packet.
Let me see that.
Give me one moment, I'm sorry. But yeah, I think it was count 5, which she found no PC for already, and that's deleted on the document.
Because I've got on my order that count 6, she said no PC yesterday.
Okay, that might be right. Let me just get to the...
All right, okay, so count 6 says no PC. So, State, did y'all perfect on that count 6?
I'm checking the emails now, Your Honor.
I'll sit right here.
All right, thank you.
I'm sorry we couldn't use you. But next time you're going to be top of the list.
Thank you. Thank you.
Always a pleasure.
Judge,
yes, sir.
I noticed everyone started eating as soon as that gentleman started talking about his restaurant. What's up with that?
Well, I know it now because I was taking my wife to Burger King. You got a 2-for-1 tonight. On Valentine's Day until 6. If you get one Whopper, you can get your wife a Whopper for free. I was going to take my wife to Burger King, but now that this guy said filet mignon, I'm having second thoughts. I might take her to a Japanese steakhouse now.
What's the court case number?
I think your wife would prefer that one, Your Honor. Yeah. We're in no rush, folks. I think this is our last case, so take your time.
Your Funches, yeah.
Mr. Miller, I saw you walking around the court off 1 week there a couple weeks ago. And you also on the weekends. Do you ever get a day off? What day are you off, if ever?
Judge, I work, well, you know what I've got going on the outside. Sometimes I trade with people so that I can get some coverage during the week and have some time off.
I see. Okay, because I know I saw you. I was looking out the window and I saw you walking someplace during the weekday, and I see you every weekend.
Oh man, 5 or 6. We know it.
Thinking, man, does this guy get a day off?
And I gotta say, I really lucked out today. I was expecting an entirely different judge. I'm really happy you're here.
Yeah, I'm happy to see you. I'm going to be back also the last Saturday. I had to switch. I started a boot camp program.
Huh?
So on Saturday morning, I got to be there like 5 in the morning. So
No, are you going through boot camp? Or are you
yeah, I
drill
started
sergeant?
boot camp. Yeah, I had so I'm just trying to get my weight off and so forth. But anyway, so I can't do Saturdays for a while. So Judge Zeller switched with me. So I'll be back this Saturday. I can't be here the last Saturday of February. I'm going to be here. The last Saturday in February, I'll be here for my other day. Okay. We're back on the record, folks. Let's get going. Where
Yes,
we
sir.
going?
Bunches, there was, I believe, a 5 and 6 yesterday when I was here. The judge, there was one that they found no PC for at all, so it's off the docket. We're at 6. She was inclined. The judge was going, because of the fact that there was issues, she gave the state time to look into that further and set the bond at $20,000 because he needed, it was no bond before. And so we were saying, Your Honor, he's entitled to a bond, he's entitled to a bond, but the state asked to be heard today on count 6. And so she just set it at $20,000 instead of no bond because she didn't want to hold him no bond when he was entitled to a monetary bond. So now we're back to one, look at the bond, because that's what I put on the record yesterday, that you could review the bond in addition to what the state wanted to look at because that was the only issue, that count.
Judge Zeller is a genius at this stuff, and she has forgotten more law than I even know. But I thought that a perfection proceeding stays or continues the so-called magistrate proceeding. So I've got on my notes, her notes, that I've got a bond for she scratched out, and she put $20,000 on count 6, and then she wrote no PC, set it the date February 14th for a perfection. Now, quick question, Mr. Pryor.
Yes, Your Honor.
Did the state come back with any? Did the state attempt to perfect, or does the state wish to perfect?
The state wished to perfect, Your Honor. The state would ask that it could be extended another 24 hours based on law enforcement officers trying to get us the information and a supplemental report in reference to this case. I've checked my emails. I've checked the documents in relation to magistrates today, and I still don't have anything in relation to that. So the state will respectfully ask that we have another 24 hours to perfect by Monday.
And that was the same issue raised yesterday, Your Honor, that he's been in custody. Now this is an add charge. There were 2 more charges added, and they already know info the previous charges apparently, and I was asking just so I'm correct on the record, that the other counts 1 through whatever 4 were no info. So the judge was asked, the state asked for time to perfect. There's nothing again today. So we were asking for a bond, a bond amount, because we was being held no bond.
She said it at $20,000.
Just to give the
Right.
state time to perfect, but now we're now asking for you to give a reasonable bond on this case, Your Honor, and the state can do whatever they need to
And
do.
what's the bond? And what count was the bond issued on?
There was an NB on count 6, and the judge set it at 20, just in a,
Okay.
just to throw out a number in a sense, because she was giving the state time to perfect anyway, and he was entitled to a bond, period.
Okay.
So I'm just asking for a lower bond amount for Mr. Funches. He has been around a couple of times on these cases.
What was the ad charge?
That's what I took my wife to. You've been to Paris before?
I have been.
To the Eiffel Tower.
I have been to the Eiffel Tower.
That asparagus cost $30. I told somebody, I told him, I said, can you give me something relatively cheap? And so he gave me some, it was $30 just for the asparagus alone. It was nice because I'm on vacation. But the point is, when you say a lower bond, Bachelor, give me a number. I gotta have a number, otherwise I'm paying $30 for asparagus. Give me a number.
Well, Your Honor, if you're inclined to have him supervised by pretrial,
Yeah.
I understand the allegations in the warrant speak about a potential folding box cutter knife. However, that was the issues at the state, and I know Ms. Strickland made a very good argument yesterday, which I can't remember all the details, but if he was placed on some form of supervision, Your Honor, and given pre-trial, I believe that he would be an amenable candidate. Understanding that this is an aggravated, it's charged as an assault, but there is a lot of information that was needed to look into. So I'm just asking for a lower bond amount. If Your Honor wants to set this at ROR him to pre-trial with a GPS monitor and allow him to have an open schedule, he's being monitored, he has a GPS on him, and so everybody's safety concerns, as at least to his whereabouts and where he is. No return to the location that this incident happened at. That's what the defense counsel would be asking for.
What's your thoughts, Mr. Prosser? I mean, I want to give you, The problem is if you're asking me for 24 more hours, I'm duty bound somewhat inclined to give it, Mr. Pryor. This is is Valentine's Day considered a holiday, a national holiday?
I don't know, Your Honor. I don't think
It's not
it
a
is.
national holiday, Valentine's Day?
No, Your Honor. So everybody should be working. And then you can work.
You know what? You got a point because this was a Monday, nobody be off. So it's not a national holiday, Pryor. You won't be off, but this is Monday, you be going to work.
I'd be at work, Your Honor. Your Honor, the reason, Your Honor, here's why I would object to the bond being put down to a strict pretrial, standard pretrial, or just a pretrial in general. He has priors, Your Honor. I mean, although I don't see any violent priors, he does have a prior drug-related offense, possession of cocaine, and a possession of PVP in which he's adjudicated guilty in 2014, a petty theft. Your Honor, I have concerns for the victim in this case. I have, well, the overall community, overall community in this case, the fact that he had drugs in his possession, the fact that he has a prior drug offense, and the fact that he had a box cutter or alleged box cutter in his possession. As a state attorney in this case and representing the interest of the citizens of the state of Florida in this state, I would have some concerns with him being able to move freely and about throughout Broward County with relation to the charges that are being brought against him. So I would respectfully request that this court keep in place the $20,000 bond and that we be given another 24 hours to perfect.
Okay, let me leave my record. Okay, I'm going to go ahead. I'm inclined to agree with the state. I'm looking at this PC.
My turn.
The last line of the PC says clearly. Yeah, go ahead, Mr. Miller.
Thank you, Judge. Mr. Funches, Judge, is a lifetime resident of South Florida with strong family ties, including his mother, his father, and his sisters, everyone. He works at Mazzoni Food Distribution in the warehouse, Judge, and he's been doing that for about 6 years. And I'll just ask the court to infer that a box cutter is a tool of the trade of someone who works in a warehouse. He does have some money in the bank. He is going to have to self-bond. We would also like the court to know that he works on Sundays at Bethel Baptist Church in Dania Beach, where he plays the organ and has done for the past 6 years. I would ask the court to consider these mitigating factors.
Hold on. What Baptist church in Dania?
Bethel.
Bethel?
Yes, sir.
Bethel?
Yes, sir.
Who's the preacher at that church?
Pastor Pope.
Pastor who?
Pope.
You play the church organ?
Yes, sir.
That boring music I hear sometimes?
Yes, sir. But I'm not born on my organ. I've been in music ever since I was a child.
Yeah, I think I delivered a sermon down there one day. I'm trying to think. It's about 3 different Dania churches I've been down there. Here's what I'm going to go ahead and do. Here's my concern, Miller. If I look at the last line of the PC, this is what it says. A routine records check revealed Funches had an active capias for petty theft with a $500 bond. I'm only here to assure people can come back to court. How do I weigh the argument if there's already a capias out for him when he's arrested on this particular case?
Well, that issue has been resolved, Judge.
But the point is, it was an outstanding capias was his point.
Yes, sir.
I'm going to go ahead. Huh?
Judge,
and again, folks, I'm speaking of count 6.
My understanding, Judge, count 1.
Yeah, 1 through 5. What happened to those counts?
The bond is $10,000 in that. It's actually a more serious charge.
On count 1.
That's my understanding, yes.
Okay, so again, Judge Zeller is a genius compared to myself on these matters. I'm going to go ahead. I hear you. I'm going to go ahead and give him a GPS monitor. I'm going to still set bond at $10,000.
Your Honor, but I have to interject. It was just communicated to me by pretrial that he was just released.
State prison in October of 2015.
Right.
Nobody told me this.
Yeah.
Okay, it stays the same. Bond stays the same. Mr. Miller, he just got out of state prison, sir, in 2015. Are you aware of that?
What?
Are you aware of that, Mr. Miller?
Not at all.
Yeah, he just got out of state prison last year, folks. I'm gonna go ahead. It is what it is. Bond will stay the same at 20,000. I'm gonna give the state 24 hours to perfect. Thank you very much, Mr. Propper.
Thank you,
Judge.
Thank you.
That clears our courtroom.
Yes, sir. Thank you. I think we're done, guys. Yeah, you guys. I'll see you guys the last Saturday in February. I'll be back here. Good luck, guys. Have a happy Valentine's Day, everybody.
All right, take care, Judge.
All right, thank y'all.
Take care, everybody.
What's your recess? What are you doing tonight?
Oh man, I am probably me and Nikki, I'm gonna do it like a little picnic dinner type thing.
You cooking?
No, I'm ordering out.
You can't cook nothing.
I can cook, man. I'm country.
Mike's live.
Judge, I'm country, man. I can
Have a
cook.
picnic today.
I can throw down a little bit.
My wife, I said she got to cook some Burger King. I made reservations last week at the Japanese steakhouse. But I got to think she wanted Burger King.
Oh, good. You gotta keep them surprised, man. Thank you. Gotta keep them on edge.
You got people on edge, don't you?
Mike is still on? Yeah.
Is the mic still on? Yeah.
Okay, thank you.
I think we're done. We done?
Yep.
All right.
Oh, this garbage right here?
I thought we'd be out by 10:30.
Me too. I was looking at the docket.
We don't have NCIC. We don't have
Really,
any.
really careful. All right.
We don't have that.
Just take your time with your kids. So tell me. I've been worried about you. I've been asking Mike about you.
He doesn't even have access to NCIC. There's
Yeah,
people
I don't
in his
have
office that
access.
have access to
Yeah.
NCIC. Well,
Yeah,
none of
but-
us, I love NCIC, but they won't give anybody
They won't give
access.
us, even David.
Thank you.
Only supervisor. Yeah, only supervisor. And all that, yeah. I never understand why anybody
I
should
get
reach
it,
out.
but when I get.
Take care, everybody. Happy Valentine's Day. All right, take care.
My judge waives all costs because I asked for it. I know.
All right, guys.
All right, bye
Bye.
HP,
Bye,
happy
Kim.
Valentine's Day.
All right, you too. Have a good one. Treat my boy Toby good tonight, all right? Treat him good tonight, all right?
Yeah, oh, sorry, excuse me.
Everything? Okay, I'll put the docket on the chair as soon as you go down the escalator.
Okay, I'll wait here then.
Unless you want me to put it in the box.
No, put it in the chair. I'm gonna.
Okay.